It's Friday Night Live. Welcome in. I am starting off the evening with watermelon kombucha. It is an alcohol-free evening for me because we've got a lot to talk about. I have a very busy weekend. And it's just it just is. I feel like every Friday I'm like, you guys, it's so busy. But the law does not stop. The law does not wait. The law does not give us a moment. So tonight we are covering a lot of different topics in the weekly roundup. I am going to talk a bit about the search warrant for Brian Laundrie and kind of the procedural side of that. I know there's a lot of frustration around this case. And so I'm hoping to bring the perspective of not just a lawyer, but a former prosecutor with, 15 years experience, like doing legal shit. So hopefully that will help a little bit. It's not going to ease frustration, but hopefully it will explain what the procedure and the process is that we're going through with that. A very quick Hayley Paige update because the court denied her again. And at this point, it's just kind of funny to me. We've got a YouTuber arrested for a alleged $30 million cable TV piracy scheme and is facing up to 500 years in prison. So we're going to talk about that for a minute. We have some new Britney Spears motions. Another fan has filed a motion to dismiss or a motion to terminate the conservatorship. I'm fascinated. And then, of course, Josh Duggar's legal team filed 4 new motions. These are replies to the government's motions that we talked about last week. We've got some fresh hair. We've got a fresh iPhone. It's time to roll. Are you guys ready? Are you ready? Are you ready for Friday Night Live? I'm ready. Let me know where you're coming in from. And if it is your first time on a live, just go ahead and put a 1 in the chat for being here. I said it was a full one tonight, and it sure the fuck is. It sure is. So we're going to just get into it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. It's so good to see everyone coming in. And of course, replay crew, love you. There will be timestamps down below. And if you are going to come up into my live for the first time and leave comments, no, this isn't the law nerds that do this. This is people who wander by for a topic off the street and then act like they have no home training and say things like, girl, shut up. You go off track too much. Yep. Sure do. That's what we're here for. We're here to talk about the things. It's a conversation. It's not just an information dump. And then you might get a clap back in the comments. That might have happened earlier this morning. It was one of the first comments I saw this morning. So I was like, it is what it is. Watching from your boring office in Joint Base Pearl Harbor, Hawaii. Well, Pearl Harbor, Hawaii is lovely. And I'm glad you're watching from your office and it's boring enough that you get to watch. Christina M., we are going to talk about the police being at Brian Laundrie's house. I just saw reports on that, and it looked like there was already some reports about what that was about. It was just responding to a call. So we will absolutely get into it. Saskatchewan has to be my favorite place, full of consonants and lots of fun things to say. So, Misha said 500 years in prison. Did I hear that correctly? Yes. Yes, girl, you did. It was so nice meeting you this morning on Clubhouse. Yes. 519 years to be exact, in a $30 million scheme with a YouTuber I had not heard of. But when I started kind of going down the rabbit hole onto their channel today, I was like, oh, there's some interesting stuff here. Seems like a super cool guy. And has addressed this case. So this is going to be another, let's look at the stuff. And if you want to go into his channel and look, he's talked about this on his channel a lot, denies these allegations, and has quite a lot of input on it. So I think it's a really interesting case to break down the 69-page indictment. But we'll get there. We've got to get into the Brian Laundrie case. First, Alyssa said, watching from my hospital room, I hope tomorrow I get to go home after getting COVID. COVID sucks. I agree that COVID sucks. I am sorry that you are in the hospital. Fingers crossed that you get to go home tomorrow too. We're going to cross I can't cross the sparkly ones. They're hard to cross. I can only do these. They are not skilled. They are not skilled at all. All right, let us get into the weekly roundup. And even though I have a jovial mood today, our first topic is not jovial at all. And let me make sure I have the documents pulled up before we get into what's going on with Brian Laundrie. And I don't think that I do, because I think they're just screenshots at the moment. Where did I put them? Everything else is literally pulled up, but it just is. We're professionals here, people. This is what we do. And I've got to just find where I have so many cases now that we're following that it is hard to find all the things. There we go. All right, let us get into the weekly roundup real quick. We have 3 topics in this week's weekly roundup. I always feel like I should also sing like roundup. I don't know. Like I hear the Yahoo kind of thing in my head when we talk about it. So we're going to be talking about Brian Laundrie. I think it's Laundrie. Here's the thing. Just disclaimer and warning for all of you that are new here. We don't name call in the chat no matter how much we think somebody sucks. We are respectful law nerds, and we are here to talk about the facts. I know there is a lot of information out there around this case. Not all of it's accurate. Not all of it's confirmed. I know it is difficult, and we really do try to make sure that we remember that you are innocent until proven guilty, no matter how much we fucking hate it. And no matter what the facts of a case are, the legal process will go through its process, and we will be here to talk about it every step of the way. It is a process. It's called the legal process for a reason. Justice does not work quickly. So even though we all have our individual opinions, feelings, and thoughts, we really do not foster hate towards anyone in the comments, even when that is challenging, because one of the things that's special about being a law nerd is you evaluate the law separate from evaluating your own feelings. And that is a critical thinking skill that is imperative in court, but it's also something that we don't get to practice a lot. So we're all going to practice it together, being like, my feelings are this, and the law is this. And in a criminal prosecution, fast can equal mistakes, and mistakes can equal appeals overturned, constitutional rights being trampled. And when that happens, it is so difficult because you get a conviction. And then if there are things that are missed, you can have that conviction overturned, and it just doesn't feel like justice. So I would rather take a slow and considered prosecution and investigation, rather a rush to determination and a rush to outcome determined investigation. I prefer that an investigation starts with the thing that happened. And in this case, it is the homicide of Gabby Petito, and then go from there. Follow the logical steps. Yes, there's a person of interest. And yes, that person of interest is her fiance, Brian Laundrie. He is the last person that we know to see her alive. Therefore, he is going to naturally be a person the police would like to chat with. And they now have an indictment against him that was handed down yesterday, September 22nd. It is a 1-count indictment. And the 1-count indictment is, we're just going to go over it real quick. It is very brief. It's very brief. From on or about August 30th, 2021 through and including on or about September 1st. Things are always pled on or about because sometimes by the time you get to trial, witnesses or dates can vary. There can be fluctuations. So it's always on or about. If you just put on and then it's proven to not be on that exact date, you can lose your entire case because it's not pled properly and proper notice isn't given, et cetera, et cetera. So it's always going to be on or about, even if they are really, really, really sure that that is the date that they're thinking of. So from on or about August 30th to and including on or about September 1st in the District of Wyoming and elsewhere, which means this could have started in Wyoming. There could be other jurisdictions. Defendant Brian Christopher Laundrie knowingly and with intent to defraud used one or more unauthorized access devices, the device being the Capital One bank debit card with the last 4, a personal identification number, so a PIN, for bank accounts, and then it gave the bank account numbers and by such conduct obtained things of value, generally money in this case, to $1,000 or more during that period, which affected interstate commerce. That's the jurisdictional part of this. Um, and the value aggregating 1,000 is probably the charging, and I didn't pull up the charging guidelines, but probably the charging guideline for this to be a felony. It is in violation of 18 USC 1029A2 and Section C1A1. What that means to me, here's what I have taken away from this. One, this is a ATM card that he's not authorized to use. This is a PIN number that he had, and he used it to access bank accounts, probably a checking and savings that are connected. That is speculation, and that is based on nothing other than the fact that it's two accounts. And then withdrew money. Now, my speculation and the wide speculation is this is likely Gabby Petito's card and her debit card accessing her bank accounts. The indictment does not say that. The grand jury would have been presented with those details, but the indictment does not name it because the thing is the debit card and the bank accounts, not the name. So it is likely to me and highly likely to me that that's what it is, but that is not stated in the indictment. But what is stated in the press release that was issued along with the indictment is that this charge comes from Brian Petito's I apologize, Brian Laundrie's, because I'm looking at Gabrielle Petito's name on this and trying to say Brian's name at the same time, and they just conflated. This comes from and is related to Brian Laundrie's activities following the death of Gabby Petito. That is what is in their press release. They say that on Wednesday, September 22nd, the U.S. District Court of Wyoming issued a federal arrest warrant for Brian Laundrie. The warrant was issued pursuant to federal grand jury indictment for a violation of federal statute 18 USC 1029A1. And this is 1029A2. So the press release and the charging document are different. The different subdivisions aren't going to be a huge issue because what matters the most is that the indictment is right. You can arrest someone subject to an indictment, but they put 1029A2 in the indictment and 1029A1 in the press release, which is just, not ideal. And when I was reading it out yesterday, I didn't even catch it. And Nate, the lawyer, texted or messaged me this morning and said, me going like this, messaged me this morning and was like, did you see this? And I'm like, I didn't even catch it, that it was the two different subdivisions. Probably won't be a huge issue, but it is what it is. So this tells me that, again, it was likely hers. Again, they likely have a date of death that is in that time frame before September 1st. That would have been presented to the grand jury. And then they talk about the warrant. Well, this warrant allows law enforcement to arrest Laundrie. The FBI and our partners across the country continue to investigate the facts and circumstances of Miss Petito's homicides. So that means that this is not a warrant, and I've seen confusion about this. This is not a warrant related to her passing or him being a suspect in her murder. This is a warrant for the use of a debit card. It's generally a holding charge, so it is going to be something that they can arrest him on, search him on, interview him on, bring him into custody on, keep him in custody on, seeing that he's been missing for over a week and a half, put the ankle bracelet on him if he's released to track him. This gives them something to go on while they continue to investigate, which means they don't have to rush the investigation. They don't have to rush the autopsy and things like that. So this is what it is. So they go on in the press release to say that the FBI continues to seek information from anyone who utilized the Spread Creek dispersed camping area between August 27th and 30th, who may have had contact with Petito or Laundrie, or who have seen their vehicle. They give the tip line. If, this is a see something, say something. If you see something, then say something. If you know someone that was in that area, encourage them to give law enforcement whatever information they may have. Those are the kinds of things that are going to help find Brian Laundrie, who we don't know where he is. They have been searching one place, it seems, for him over and over and over. It seems like a difficult location to search. We'll see what happens. Let's get into the arrest warrant real quick. It is a very basic arrest warrant. And again, the arrest warrant has the 18 USC 1029A1, use of unauthorized devices. And in this, it's a 1029A2. Again, that's not going to invalidate the arrest warrant. They might file for a updated or superseding an arrest warrant. The indictment is enough to arrest. So having the wrong charge on it's not going to be the end of the thing. What else? I've gotten asked a lot about the vehicle because it seems that he or someone drove the van that is Gabby's van back from Wyoming to Florida. The thing is, it is pretty hard to prove that he didn't have some kind of permission. The two of them were living in the van together. It hadn't been reported stolen for obvious reasons. So that is a harder charge. With this, it's a financial charge. So when you're looking at unauthorized access, is his name on the account? No. Okay, then he's not authorized by the bank to access it. Even if somebody said, yes, you can access it, you can say that the bank didn't give him access. It's like using a credit card. You don't need to bring in the person whose credit card was stolen. You need to bring in the bank to say this credit card or this debit card wasn't issued to that individual, and therefore the bank has not given you access to it. So you don't have to bring in the victim, as it were, of the financial crime. And this works in stolen credit card cases when victims can be all over the country and sometimes all over the world. The bank can come in and testify. So you get a bank rep to testify that this person's name is not on it. Therefore, they are not authorized to use that debit card. The debit card's issued to the person it's issued to. Then you bring in the records that it was accessed, likely at an ATM. And if it was accessed at an ATM, you bring in the camera footage from the ATM and show the picture of the person. You show how you know it's the person you are telling the grand jury that it is. And you say, this person's this person. They access this account and the bank says that they don't have permission to do it. And that makes it a very simple card. Or a card, as my phone's going off, a very simple financial crime to be proven to a grand jury and proven down the road, which makes it much easier and cleaner for law enforcement to get a warrant on this and move forward this way than to wait longer to have a warrant out for Brian Laundrie, who is a person of interest still in the death of Gabby Petito. Hopefully we will say, or we will see what we will see what happened. I mean, they can't do much until he's arrested or found. They could indict him again before he's arrested or found. We will see if they do that. They may choose not to and just try to indict him on this, and we will see. So there you go. That is kind of a breakdown of this warrant and what I think about where we're at with this case. Again, the Petito family is going through the most awful thing you can imagine. I know there's a lot of social media interest in this case, and I hope that that interest focuses on finding Brian and keeping the tip lines out there and making sure that his face is out there on social media. So if people do see him or recognize him, that information is then given to the FBI, whether it's within the United States or not within the United States. And that's really the reason I am still talking about it. One, because I think there's a lot of misunderstanding about what the warrant and the indictment are for. Two, my thoughts as a prosecutor on how that kind of goes down and why this charge makes a lot of sense. Because one of the first things they would do in a missing person is try to pull up the financial records. Because if somebody's missing and they're an adult, it could just be that they're out of communication. So they're going to, when they have probable cause to do so, pull their bank records and see if they can track down where they've been spending money or using debit cards or ATM cards or credit cards, pulling phone records and things like that. So that's what it is. Yeah, that's what it is. I will keep an eye on it for sure. I don't love the wall-to-wall coverage on it. There's a lot of other things going on in the US right now that are not easy to talk about, fun to talk about, or So there's a lot. And it's a lot for her family. So I'm not going to, when there's new info that I can help, I will cover it. If there is just speculation, I'm not going to cover it. And that's how we're going to go forward. If there's little stuff, I will be covering it on Twitter and Instagram and mention it when we get into this. But I'm not going to, with this case, I'm not going to go live every time there's something new. It just doesn't sit right with me to dissect it like that. And I know people are curious, and I will try to keep up to date on solid new developments and new information. So that is what it is. Yeah. So that's what it is. All right. Moving on to Hayley Paige. We need to move on. Cheers to the Launards. Thank you for being respectful in the chat. This is a quick one. If you're not following along with the Hayley Paige case, Hayley Paige is fighting in a knockdown, drag out, winner take all, loser take none fight with her former employer, JLM Couture. She was a wedding dress designer. She has been vocal about this case on social media, and the judge has continued to shut that down over and over and over again. She's been ordered to take down posts. She's been ordered not to launch a new line. There was quite an extensive, and I've talked about this on this channel a bit. There was quite an extensive preliminary injunction. And then there was a contempt of court that was also quite spicy. Like, the contempt motion was spicy. Well, Hayley Paige appealed it. She asked for an emergency stay of part of the preliminary injunction. The appellate court yeeted that almost as fast as it was filed. Within like 3 days of it being filed, the appellate court's like, yeah, what we're not going to do is anything. We're not doing that. So this is just the one page from the Second Circuit Court of Appeals saying, appellant being Hayley Paige, appellant filed an emergency order seeking a stay of paragraph 3B of the district court's preliminary injunction order. That's the one not letting her do the things, pending determination of this appeal. So there is still an appeal over the preliminary injunction. This was an emergency stay. Okay, what's up, Nick? Good to see you. Oh, wedding dress designer. This one's going to be fast. Don't worry. She's been whining a lot about this case on social. She sold her name, and now she's really mad. She's big mad, and her employer keeps winning in court like over and over and over and over. She is appealing the preliminary injunction that took away her Instagram account, gave it to her employer. She's not allowed to use her name in commerce. She's not allowed to launch the new dress brand under any name, et cetera, et cetera, et cetera. So she appealed it, and then she sought an emergency stay. So an emergency, don't let it be enforceable, and an appeal. The court said no to the emergency stay pending appeal, which means it goes into effect. And not only does it go into effect, but she also has already been held in contempt over not adhering to it. So there's that. Of course, JLM is appealing the motion, which is just, to the extent appellant seeks an immediate stay pending determination of the motion for a stay pending appeal by a 3-judge panel, the request is denied. And this is over and over and over that she is trying to end route these rulings, and the court is like, no. You signed a contract. You sold your name. The company's likely to win on the merits. So I issued a preliminary injunction. You're not getting your Instagram account back. And that's what this is fighting over, which is what is so interesting. They are fighting truly over an Instagram account. And that just shows you how we are in such a different place than 5 years ago. I couldn't have imagined people fighting it out in this expensive world of civil litigation over the use of an Instagram account. But that is where we are with how much the creator economy has grown and how valuable the assets are that are social media, and how valuable the creator and influencer economy is, that this company is willing to fight for the Instagram account they started. The biggest takeaway from Hayley Paige is know what's in your contracts. Yes, your name is something that can be sold and you can be barred from using it. There are plenty of artists, Prince, makeup artists, fashion designers, Kate Spade, Bobby Brown. There are plenty that can tell you about selling your name with a brand, which is why when you think of personal branding, you have to think twice about whether you ever want to sell your brand. Because if you build it around your name and want to sell it, yes, you can sell your name, but then you can't use it in commerce the same way. And social media accounts are absolutely business assets. If you build a social media account around your work while you are an employee, that can be an asset that belongs to your employer. So be mindful. Also, because of the contempt hearing, Hayley Paige now also has to pay her employer's legal fees. For all the litigation that dealt with the contempt hearing. So it's like insult to injury and more injury. They took her Instagram. She has to pay to fight. She now has to pay because she's caused her employer to fight. It's a mess. I don't think she's going to stop. It's a cautionary tale, but also it's a cautionary tale when you are in litigation that you have to be very, very mindful of how you talk about litigation, which takes us to the next topic tonight about talking during litigation. And this is not casting judgment in any way, because I've watched a number of videos by this YouTuber, and I don't think they are talking kind of out of school about their case. They were raided by the FBI 2 years ago, but there are quite a lot of, well, not quite a lot, there are a number of videos about their pending case, and it allows us to kind of go, oh, this is what's going on. And it's been very interesting for me to look at the indictment of Omi in a Hellcat, or Omi in a Hellcat, and their channel and what they're accused of. And it is just wild stuff. So let's talk about a YouTuber that is apparently facing over 500 years in prison. Yeah, that's what I said. I said what I said. Omi, OMI, in a Hellcat is been indicted in a $30 million cable TV piracy scheme that they on their channel have denied. These are allegations. Lawsuits are allegations and shade. Indictments are allegations and a grand jury. Generally not as much shade, but it is just the wildest thing. And the first person that shared this with me was our mod, Chris Riley. Thank you, Chris, for sharing it with me. He was like, they're going to be interesting. I'm like, oh, this is going to be interesting. This is going to be interesting. So again, with their channel, you can go look at the videos they have up talking about this case, and seems like a good dude. Like, I watched the videos, I was like, oh, seems like a nice dude. Has been very mindful in the way that he has spoken about this case, but has spoken about this case. And let's pull up the article and then pull up the indictment, because it's fucking crazy. It's fucking crazy. This article comes to us from Law 360, and I already see you in the chat going, murderers get less than 500 years. No, this is not what they are going to get. Look, some of these things might stack. This is when you take all of the different counts together in the indictment, when they stack together. This is like the maximum potential thing. That's the maximum exposure. Will they get that? No. If they are convicted, they are not going to get that long, but this is how many counts there are. It is a 69-page indictment. The FBI raided their home over 2 years ago, took quite a lot of money and cars, like over $5 million out of a bank account and cars. It's in the indictment. We'll get there. There's so much in this. So we're going to go through what happened? My thing is flipped. It's flipped, I tell you. All right, we are going to talk about this article first, because it kind of gives you the overview, because we're going to scoot through the indictment, but this is wild. All right. This is from Law 360. 3 men, including a YouTuber with nearly 800,000 subscribers, were charged in Pennsylvania federal court for allegedly masterminding a $30 million scheme to pirate cable television and other copyrighted material and resell it. Why isn't Triller going after them? See, this is what Triller is trying to do, but not doing. Because what this is what Triller is alleging happened, which didn't happen. So we're going to continue to shade Triller, because this is what Triller has tried to say people did, but they didn't. Bill Omar, and I don't know how to pronounce your last name, Carrasquillo. No disrespect meant. I am the worst. of New Jersey, Jesse Gonzalez of Pico Rivera, and Michael Barone of Richmond Hill operated a criminal scheme. They're alleging these are allegations from March 2016 to November 2019, according to the indictment. And 2019 is when the FBI raid happened because they did talk about it on their YouTube channel. A defendant who's known as Omni, is it Omi in a Hellcat? Is hard for me to say because I want to say Omni in a Hellcat. I don't know. I didn't know what a Hellcat was, y'all. I got to be honest. Like, I had no idea. I found their channel fascinating. We're going to look at the intro to their channel in just a minute because this is the thing. And in one of their latest videos, he talks about maybe his lifestyle drew the feds' attention. And if you don't believe that that's a thing, ask Teresa Giudice if the feds look at you because of your lifestyle, because that is what prompted an investigation into her, is how she comported and showed her wealth online on Real Housewives. So this was the early days of it. So I'm going to get through this article and then we'll look at the intro to their channel. And again, no shade, no disrespect, just explaining that this is something else. Defendants are charged with engaging in a massive years-long scheme to steal copyrighted content, which is a serious federal crime. Copyright infringement is a serious federal, because it is. Said acting U.S. Attorney Jennifer Arbiter. Interesting. For the Eastern District of Pennsylvania. It's just because arbiter is like the arbiter. Anyway, I won't wander. As this prosecution shows, protecting intellectual property rights is an important priority of our office and the entire Department of Justice. What you are going to hear from defendants in this case is, why didn't they just sue us civilly? Right. These are things that can be civil, and they are things that are also criminal. And the Department of Justice gets to picky, choosy, and they have the power. They have the power to take your shit. Where if the cable company just tries to sue you, they have to then run you down for a judgment later. You can file bankruptcy. Other things can happen. But the thing is, civil forfeiture provisions and criminal forfeiture provisions allow the feds to just take your shit. And so why do they go after some of this stuff? Because there's shit to take. Omi in a Hellcat is charged with 1 count of conspiracy to commit copyright infringement and related offenses, 1 count of violating the DMCA, the Digital Millennium Copyright Act. Did you know it had criminal provisions? Guess what? It has criminal provisions. It's not just takedown notices. 1 count of reproduction of protected work, 19 counts of money laundering, 6 counts of wire frauds, and other charges. That could total 519 years in prison, prosecutors say. What? According to authorities, Omi in a Hellcat flaunted his fraudulently obtained wealth in YouTube videos in which he showed off expensive sports cars. He also lied to authorities, these are allegations, to try to hide some of the dozens of vehicles he owns. You can't just go and monetize someone else's copyrighted content with impunity, said acting special agent in charge of Bradley S. Benavides of the FBI's Philadelphia division in a statement. If you think they're not looking at your shit, they're looking at your shit. They are looking at your shit. So, according to the indictment, the defendants used encoders from China that were designed to strip away encryption protection from the cable TV providers and transmit the content over the internet to the defendant's computer servers. The complicated scheme also allegedly involved the unencrypted video content being transferred to servers in an unnamed foreign country, to avoid detection, I would imagine, where it was stored and made available to subscribers and to evade law enforcement. The speculation on my part, in an on-demand format for approximately 24 to 48 hours, the defendant service was known as Gears TV and Gears Reloaded and other names. We take seriously... This is an awkward sentence. We take seriously schemes for profit that infringe upon copyrights. I will tell you what, I prosecuted a fair few of copyright cases in my day as a DA. It was mostly people hawking ripped DVDs at the swap meet. It was not this, because we are not the feds, but it was the MPAA has investigators that would come out, and the people who were sharing all of the were sharing like all of the DVDs. They would go into the movie theaters and like either get screeners and rip them because LA, or record the video in the theater and like burn them to DVDs and sell them at the swap meet. And the MPAA would shut that shit down and we would criminally prosecute it. There were times I was like, really? But also then when I started talking to the MPAA, the Motion Picture Association, about how much it cost the motion picture industry, it wasn't a cost necessarily that was hurting actors, but a cost that hurts the sound guy, the people who were doing the costuming. It hurt everyone down the line, not just the the big names that you think of in a movie. Movies take lots and lots of people. Anyway, I'm off of my soapbox about copyright. The charges announced today demonstrate the department's continuing commitment to protect copyright holders from theft, and this is absolutely something they go after. But this is also a lesson to be learned, that they are watching, and they are watching when we talk about extreme wealth. They will look at the flaunting of wealth, and someone somewhere will get curious. And guess what? When you're a Fed, you can do that. You can get curious and just have a look-see at people's taxes and go, I wonder what they're up to. So Narco ASA said, oh my God, I prosecuted those cases too. The DVDs and CDs, the RIAA also had an investigator here too. I mean, samesies. All right, I'm going to pull up the channel. Where is it? I'm going to pull up the channel trailer. It is a long trailer. We're just going to play the beginning bit because, again, it's for commentary and fair use purposes, YouTube, just so you know how I'm using it. Let me pull up the sound, and hopefully this will work, because the last time I tried to do this, it sure didn't. Oh my God, it's just, well, we'll see. We'll see. This shit might be flipped too, but we'll try. We'll try our best. Let's pull it up with sound, because this is what... Okay, I'll reload it. There are multiple houses here that belong to him, according to this indictment. These cars all belong to him, but there are multiple houses here. I was not familiar with this YouTuber until like 3 days ago. That looks like a covered pool. Okay, we're going to keep going. Look at the car. All cars. Wait till you see the number of cars listed in the indictment. It's a lot. Can someone tell me, is this the Hellcat? Is that what it is? Tell me, do you know the feeling? Omi in the Lambo? Oh, that's the Lambo. My bad. Look, I like my technology. I don't know much about cars. I think that's is that the Hellcat? Hellcat? Yeah. So those are the trailers for the channel. As I said, he talks about this. He talks about this in this video. The FBI is back. My biggest regret. When I went and looked at his channel, the first thing I did was go and look for the most recent, the videos with the highest plays, most popular videos. I got to sort by most popular because I was trying to get an indication of what his channel was about, which seems to be money. But the FBI seized everything from a year ago, really broke down what was going on with the FBI seizing everything. The comment is, I would be so annoyed if I was their neighbor. He owns a number of those houses. A Hellcat is a Dodge. Thank you. I appreciate that. I didn't know what it was. Okay, let's just get into this very extensive indictment, because this is not our main story for the evening, but I think it's fascinating. Anytime you're like, okay, 500 years for copyright infringement, I have questions. A Hellcat is a Dodge Challenger with a specific motor. Awesome. Does it growl? I bet it growls. I bet it does. Look, I like a nice purse now and then, but yeah, I think he does have the whole cul-de-sac to himself. All right. Let's go back and share screen and get into this indictment. Okay, this indictment perso all pissed me off. Whatever boomer scanned this indictment in, yes, I'm calling you a boomer. It is scanned terribly. It is scanned terribly. It is flipped. It is shifted. It is not my favorite. There are some pages of this that I will skip past because they have home addresses on them, and I will do my best. These are public records, but what we're not going to do is make it easy for people, All right. I don't know what, AKA Target. Do you get to name yourself Target? Does the store have issue with that? I have questions. These are all the charges. 1 count of conspiracy, reproduction of protected work, public performance of a protected work, 19 counts. That's like distributing copyrighted work, basically. Access device fraud, 4 counts. Wire fraud, 6 counts. False statements to a bank, 3 counts. Engaging in monetary transactions derived from specific unlawful activity, 19 counts. That's a very specific type of money laundering. False statement, 2 counts. Removal of property to prevent seizure, 2 counts. That means if you know it's coming and you try to get rid of your shit, don't delete your shit. Not only don't delete your shit, but don't get rid of your physical shit. Don't hide your shit. Don't yeet your shit. So, introduction and background. Defendant Omi, which is what we're going with. That's his YouTube name. That's what we're going with. That's how I'm rolling. Is a resident of New Jersey. Other defendants are residents California and New York. Persons 1 through 13 are individuals whose identities are known to the grand jury. Foreign Company 1 and Foreign Company 2 are foreign companies whose identities are known to the grand jury, which means the grand jury heard from 13 different witnesses or cooperating witnesses and told them shit. So they had a lot. Comcast Corporation was a video content defined below. We know what Comcast is, an internet service provider headquartered in Pennsylvania. At certain times during the scheme, Comcast offered its video through a subsidiary known as Xfinity. Comcast offered subscriptions to video content and internet services in a fee-paying subscribers. Much but not all of the video content offered by Comcast was protected by the Copyright Act, and Comcast was licensed to deliver the copyrighted video content to its subscribers. Customers who signed up to receive cable television services from Comcast were subject to terms of service which are provided to the customer. Can we see which way this is going? Verizon Fios is a video content and internet services provider headquartered in the Southern District of New York. Verizon offered subscriptions to video content and internet services to its fee-paying customers. Much but not all of the video content offered by Verizon was protected by the Copyright Act. Charter Communications, same as above, but is doing business out of Connecticut as Spectrum Charter. DirecTV, kids are all here. All of the service providers, all of the content providers, kids all here. DirecTV, video content provider, protected by Copyright Act, located in California. Frontier Communications, same, located in Connecticut. Comcast, Verizon, Charter, DirecTV, and Frontier, collectively VCP, video content providers, acquired and curated their collections of video content, which is defined for the purposes of this indictment, movies, TV shows, and other audiovisual content based on their particularized assessment of what their subscribers would find to be entertaining. We know generally how that works. Much but not all of the video content in the collections of the video content providers was subject to copyright. Video content providers deliver their video content in an encrypted format. Yes, they go over the air in an encrypted format. You know what? I don't think Omi has listened to my channel and listened to Ghost in the Wires, because this is feeling very Ghost in the Wires-y to me. It's like, wait, but what? I thought this was fine. And in the last video I watched, what Omi did say is, hey, I ran my business by my lawyer, which is going to be a very interesting conversation. Again, these are allegations. This is a criminal indictment, innocent till proven guilty. But said, I ran my business through my lawyer, and my lawyer was like, it's a gray zone. I'm like, copyright's not that much of a gray zone if you're restreaming things and providing it for service, but we'll just see. So, video's encrypted when it's provided. That's, how it's provided to just the people it's supposed to go to. Video content and concurrently applied high bandwidth digital content protection, HDCP, is applied to the content to make it, protected content. HDCP is a technological measure that effectively controls access to works, including copyrighted works, protects the rights of copyright owners. Because the thing is, the copyright owners have to work with the media companies to provide the movies. This is all of the negotiation that goes back and forth between studios and providers of what TV is going where, if you can or cannot get your baseball game. This is the work of lots of lawyers dealing with negotiating which service providers are providing which services. And the HDCP is the encryption of it. High definition multimedia interface. HDMI cables are often used to transmit video content. We know video content provided by video content providers could not have been copied without removing the HDCP. Foreign Company 2 was a provider of public and private cloud products headquartered in Montreal. DataCamp Ltd. operated a content delivery network, which was comprised of geologically distributed groups of servers being the computers that shit is put on. And they were designed to provide fast delivery of content over the internet. DataCamp is headquartered in the UK. CDN77 is a global content delivery network offered by DataCamp. This is okay. A merchant processor is a company that handled electronic payment. We know what that is. Any payment processor. This talks about the different payment processors. Stripe is a payment processor. B of A is a payment processor. Nuvi Technologies is a payment processor for Wells Fargo. WorldPay is a merchant processor, partnered with Fifth Third Bank. Electronic Merchant Services, EMS, was a merchant processor that allowed merchants to accept payments. These are all going to be the payment processors that were used to make the money from the business, because it seemed that he was operating an app that was providing this content. So Omi conspired and agreed with person one and others known to the grand jury. Somebody took a deal. I saw somebody in the chat asking, does anyone know how he got caught? He said that they had been watching him for about 2 years. This can either come from the cable companies noticing the behavior or from someone getting curious because of his behavior online. I'm not sure. Maybe we'll find out. Maybe we won't. I have not done a deep dive into this yet. This is a first dive. This is a splash. This is a splash into this case. If we're fascinated, we'll do a whole deep dive. This is a splish splash. So copyright infringement willfully for the purposes of commercial advantage or financial gain, takes other people's things that are copyright protected. Copyright infringement that is willful and for purposes of commercial advantage and private financial gain infringes the copyrights in motion pictures and other AV works. By streaming is a violation of 17 USC 506A1A and Title 18 USC 2319B3. It sounds like a game of Battleship or chess. Knight to E3. All right. Circumvention of access controls that is willful for the purpose of commercial advantage. That means stripping the coding off of the stream so that you can, pirate it, is a violation of 17 USC 1201A1A and 1204A1. A different version of access device fraud. Hey, who knew we were coming all the way back around? Access device fraud is knowing with the intent to defraud using unauthorized access devices, including account numbers, access card numbers, serial numbers, receiver ID numbers, media access control, MAC addresses, equipment, and equipment collectively access devices by such conduct which affect interstate or foreign commerce, obtaining property and services valued at $1,000 or more in violation of Title 18 USC 1029A2 and C1A1. This is the same charge that Brian Laundrie is charged with this access device fraud, just in a completely different context in so many ways. Wire fraud, that is devising and intending to devise a scheme or artifice to defraud, is a violation of 18 U.S.C. 1343, manner and means. Here's the interesting stuff. Those are the underlying things. For more than 3 years, defendants, person one's the person that's working with the feds. That's who person one is. You know why there's not a name for person one? Person one sat down with the grand jury and is like, let me tell you, thank you for not sending me to prison. Here's what I know. That's who person one is. That is just that, person one. And others known and unknown to the grand jury conspired to fraudulently obtain video content and subscriber fees from, at the expense of, the video content providers and money and merchant processing accounts from the merchant processors. During the period of time, they operated Reboot, Gears TV, Reloaded, Gears Reloaded. The infringing services delivered video content, including television shows, movies, to subscribers of the infringing service. So people, it sounds like, could subscribe to these apps or websites and access stuff without having to go through a traditional service provider or a traditional content provider to access TV shows and movies and shit in exchange for payment, along with infringing service. So was bro running like his own cable network? Because that's kind of what it sounds like. But if you're going to do that, you have to have negotiations directly with the networks, and you have to be like FCC regulated and all kinds of stuff. Anyway, along with infringing services, they also offered a service library called Streams R Us, or SRU, of motion pictures and other video content that had copied or was caused to be copied. They also offered video from content providers Comcast, Verizon, Charter, DirecTV, and Frontier. Let's see. They talk about the different locations where stuff was ripped and streamed. That's not going to be an issue because it's going to be, sent all over. Defendants and others known to them imported or caused to be imported from China encoders that were designed to strip HDCP from video content of multiple access devices at a time, which allowed the video content to be transmitted over the internet and copied to computer servers operated and controlled by them. So they ripped it, they put it on a server, they charged people to access it, and then people could access it without having to subscribe to Comcast or Frontier or whomever. That is what they're alleging here. Let's see. They go into where the servers were. They go into the different websites. They establish websites including gearserver.com, gearserver.net, omarsvideos.com, omarsvideos2.com, hostingbros.net, gearsiptvnow.com, targetcreates.com, myfairguides.com, myfairguides.net, reloadedview.com, which allowed subscribers to access the infringing service and related software and to subscribe to their service, and access video content and submit inquiries and requests known as tickets. Defendants and co-conspirators did not at any point seek to obtain authorization from the copyright holders. Yeah. All right. They did not at any point disclose to the video content providers that when they were signing up for residential services at multiple locations. Is that why he has so many houses? Because he was signing up for cable at all the different houses? Is that what that was? Is that why? Is that why? Is that why he owns an entire cul-de-sac? Because what they're saying is that they signed up for residential service at multiple locations and intended to copy, transmit, and stream the video content to thousands of their own subscribers. Interesting. They publicized the infringing service by way of producing videos that were posted to a YouTube channel called Target in 1080p. Target in 1080p. Defendants and others known were interacting with each other and subscribers via social media platforms, including Facebook, Instagram, Discord, and Google Hangouts. They developed software which served as a subscriber interface, like a TV guide, permitting users to see a list of particular programming and select particular programming for viewing. Okay. They had a whole service going on. They say that during the time period, they collected more than $30 million in subscriber fees. So that's a lot. And I can imagine that Comcast and everyone else would like to have their piece of that. And here we are with the criminal indictment. They applied for and obtained merchant processing accounts from Stripe, BOAMS, EMS, Nuvi, WorldPay, and others. Well, yeah, they're going to have to process them in some way. And in doing that, they falsely described or caused to be falsely described the nature of the service. So they're alleging that they lied to the different banks to process payments by not telling them what their work was, which is what these, it's up here, the lying to the banks. Where is it? False statements to a bank on 3 counts. That's probably related to those payment processors, which is very interesting. So let's continue on, because this is supposed to be a quick dive, not a deep dive. I'm fascinated. I've got to tell you guys, I am just fascinated. It's a lot of stuff. It's a lot of money that they're alleging. They're also alleging that they submitted fraudulent documents, including false and unfiled Form 1040 tax returns for the years 2016, 2017, a false Schedule C for the year 2018, a fraudulent business portfolio purchase agreement that purported to show that as of June 3rd, 2019 at 3 p.m., defendant sold a business that provided an online customer base with web hosting capabilities to a different defendant in exchange for a $3 million payment, and then 24 monthly payments of $50,000. Okay. So overt acts, that goes to the fraud. And these are the overt acts they're alleging: establishing shell corporations, obtaining video content. I mean, that's a pretty overt act. Obtaining devices to circumvent the encryption, which is also a pretty overt act. And they talk about the dates because they have all the bank records, so they're going to know the dates. January 7th, 2019, defendants caused a wire transfer of $9,890 to foreign company as a payment for 16 port HDMI encoders. They purchased 16 port and 1 8 port HDMI encoders from foreign company at $6,000. So they're looking at all these different transfers, distributing content to subscribers. And then they talk about how that was distributed, how many it was distributed, advertising the scheme on the YouTube channel, Target in 1080p, caused videos to be posted on YouTube discussing the infringing service. On May 24th, 2018, defendants caused a video called Reloaded TV live show to be posted on YouTube. So they're talking about the advertising of it, distributing the profits. And then they talk about the transfers, concealing the scheme. Let's see. On or about July or August 2019, Omi and others deleted and removed from public access YouTube videos featuring, they deleted their shit. They deleted their shit. Videos featuring Omi discussing the infringing service. So they're like, no. We've already downloaded it. Don't you worry. Count 2, the grand jury charges, and this gets into, we're not going to get through every single count because there are so many, but these are, the allegations from above and running through all the different counts. Counts 4 through 22. Okay. Person 1 and others known to the grand jury did willfully and for purposes of commercial advantage and private financial gain infringe copyrights in the following motion pictures. Here's the motion pictures and the dates. Steve Jobs, Man of Steel, Broken Famous, Boston Red Sox versus New York Mets, The Jump, Southampton versus Liverpool, Bones, Seattle Kiro News broadcast. Why? Why? Why are we going down for the Seattle KIRO news broadcast? Okay. Tampa Bay Lightning versus Columbus Blue Jackets, Game of Thrones. I mean, I get it with Game of Thrones. Raptors versus 76ers, Full Metal Jacket, which is such an old movie. Really? Who Wants to Be a Millionaire? First Take, The Predator, Wall Street Money Never Sleeps, Shameless, Open Water 3, Cage Dive, The Walking Dead. Are there others? Let's see. Okay, charges 23 through 26 are using unauthorized devices to access services at more than $1,000. And this has the who accessed what, where, and why. And that will all be known to the grand jury. And this is going to be the stripping devices. Then we've got 27 through 32, which are the overt acts for the defrauding the merchant processors and video content processors. They talk about the manner and means. This is the web logins of all kinds of different payments and where the different payments are going to, and more. This is going to the banks again, what they did with the banks. They've got charts, people. There's lots of charts and withdrawals of funds. Counts 36 through 54 are monetary transactions listed below, transacting by separate counts. In criminally derived property of a value of more than $10,000, described more fully below. This is getting into your kind of more traditional money laundering, like we see with the Jen Shaw case, of how the money is being moved around, where it's being moved to. They know where it's going, but these are mostly going, oh no, these are the asset forfeitures, because these are going into vehicles. So Chevy Corvette, Dodge Durango, Dodge Charger, Bentley Flying Spur. Oh, this is a lot of cars. That's a lot of money. $200,000. I mean, once again, if it's your money, it's totally fine. But I mean, okay, so they're going to go through all of the different large purchases because they are going to try to recover if these are assets that have not already been recovered. So let's just go through the money. Chevy Corvette, Dodge Durango. These are two cars, 2018 Jeep Wrangler and 2018 Dodge Charger for $90,000, $200,000 for a 2018 Bentley Flying Spur. I didn't even know what a flying spur was. A flying spur sounds like something that I would need Urban Dictionary to define. Like it doesn't sound like a car. Sounds like a drunken Saturday night. Withdrawal of funds from B of A to purchase a property. So $646,000 for a residence, $34,000 for jewelry, $140,000 for a Tesla Model S. Well played. We love a Tesla. A Lamborghini Urus for $233,000. A Mercedes G-Wagon for $158,000. A Rolls-Royce Cullen. Is that right? Am I mispronouncing that because I'm a Twilight fan? Possibly. We're going to leave it. We're not going to correct that mistake. For $233,000. I feel like you should name a Rolls Royce after the Cullens, because why not? Make it twinkly on the top. Don't the Rolls Royces, or is it Bentley? Don't the Rolls Royces have the twinkly lights on the top? Anyway. Who wouldn't want a vampire themed car? A Mercedes GLE for $80,000. A bank transfer between defendants for $282,000, a 2019 Dodge Challenger, $90,000, a Mercedes GT, $195,000, jewelry for $92,000. I love that they've tracked every spend and they're like, this is what we're getting. This is what we're getting. A withdrawal of funds for a Lamborghini Aventador for $530,000. Look, with peace and love, it's a car. Like, you should see what my rims look like. They're very nice rims, but I chew them up on things. That's a lot. I mean, okay. An Acura for wait. What kind of engine is in the 2019 Acura NSX for $162,000? I have questions. I need someone to tell me. Jewelry for $100,000, a 2020 BMW M8 for $154,000. So this is that's a lot of cars. And this is only the two defendants, not all three defendants. I don't know who Wolfie is, but apparently Jesse Gonzalez is also named Wolfie. See, it's not my fault that I'm making the Twilight references. His name is Wolfie. No shade. So this is using the money that was ill-gotten to buy all the things. And the government's going to come and be like, all those things, we would like them all back, please. Thank you. This is on November 20th, 2019, in a matter within the jurisdiction of the IRS, an agency of the executive branch of the U.S. government, knowingly and willfully made material, false, fictitious, fraudulent statements and represented or representation in that defendant Omi stated that he sold his McLaren sports car to person 5 prior to November 2019 in exchange for $150,000 in cash and diamond earrings when defendant knew he had not at the time he made the statement sold the McLaren to the person. So it's now, deleting your shit by selling your shit. And they're saying, no, you told the IRS you sold it. We're saying that you didn't do it. Thank you, Anya, for explaining that the NSX is a fancy sports car. I feel like it's a fancy sports car. I just didn't know. More about the statements made to the IRS that another vehicle, a Freightliner RV, was sold, but they say it wasn't sold. And when they give the name of the person, you said you sold it to person 5. That person's already told the grand jury that they didn't get the thing. Another one about a McLaren and the IRS, another one with regard to the FBI and the recreational vehicle. So those are the false statements. Counts 59 through 62. That from 2016 to 2019, they earned millions through the infringing service, which is the ripping of the things, the tax evasion, tax fraud, and then they go through the different overt acts with regard to taxes that they are saying defrauded the IRS. Then they go through the tax years. I love the tables. We love a good table. I don't love that this shit is sideways in the way that it's scanned in. All right. More. What is this? These are forfeitures. Good. Notice of forfeiture number 1. If you think that the federal government will not come and take your shit, let's talk about the federal government coming and taking your shit. So I'm going to make sure that this does not have, it does have full bank account numbers on it. Well, darn it. I'm going to show you, again, these are the different forfeiture provisions. I'm going to go through and summarize them real quick. This is all the shit that the government's identified that they would like to take. Forfeitures. Those are all, we're not done. More forfeitures. Yeah. So let's briefly summarize the forfeitures. And I would normally redact these before putting them on the internet. I did not do that yet because this is a split splash, not a full look. Oh my God, there's so many. So these, a lot have probably already been taken because he did indicate in 2019 that the FBI came and took shit. So the first forfeiture is $34 million in a forfeiture money judgment. And they identified the different bank accounts. $5.2 million from a TD bank account, $500,000 from a payment processor, $294,000 from a Bank of America account, $440,000 from a different Bank of America account, $173 from a FNA Federal Credit Union, $20,000 in currency seized in a search warrant at a house, $1,000 seized in a search warrant at a different house, $20,000 seized from inside of a Bentley. And they gave us the VIN number of the Bentley. $80,000 seized from inside a Mercedes. Look, if you have $80,000 of cash inside of your car, we're going to have a lot of questions. The IRS is going to have a lot of questions. $60,000 seized from a home in Pico Rivera. A 2019 Jeep Wrangler was seized. A 2018 Dodge Commercial ProMaster WB High Roof was seized. A 2020 Lamborghini Huracan, Huracan. A 2019 Suzuki motorcycle. A 2019 Chevy Camaro. A 2018 Dodge Durango. A 2019 Suzuki motorcycle. A 2019 Yamaha four-wheel off-road vehicle. A 2020 Jeep Gladiator, a 2019 Dodge Challenger, a 2018 Suzuki motorcycle, a 2017 Ford F-350, a 2019 Can-Am Ryker. I don't even know what that means, but it's in the vehicle section. A 2019 Audi A7. I love an A7. They're great cars. A 2018 KTM Super Duke motorcycle, a 2019 Ford Mustang, a 2019 Acura NSX, a 2015 Lamborghini Huracan, a 2019 Lamborghini Aventador, A 2018 Jeep Grand Cherokee, I can pronounce that one. A 2019 Mercedes-Benz GLE AMG Sports Coupe. A 2020 Toyota Supra. One Bentley Continental GT Super Sport Coupe. One Jesus, there are so many of these. One Grand Cherokee Trackhawk Supercharged. A 2016 Ford Mustang, a 2016 Dodge Charger. These are all separate vehicles. We're not done yet. A 2017 Chevy Tahoe, 2019 Honda Civic, a 1996 Chevy Caprice, vintage, we like. 2020 BMW M8, 2019 Chevy Corvette, 2019 Dodge Ram. This is insanity. One Backdraft Roadster Coupe, like not the movie, but like a car. One 2016 Dodge Challenger. We're not done yet. One Mercedes-Benz GT 630 C4S. A Dodge Grand Caravan SE. Wait, is that a minivan? Do we have one minivan? I think we have one minivan. A 2018 Polaris Outlaw, a 2019 Polaris Ranger XP with a plow, a 2019 Yamaha 50 Child's motorcycle. Wait, they took the kids' toys. Guys, leave the kid their motorcycle. I mean, come on. A 2020 Yamaha PW50, a 2018 KTM 690 Duke. Holy shit, there's a whole nother page. Okay, a 2019 Yamaha Raptor, a 2019 Honda 110 motorcycle, 2019 Polaris Razor ATV. These are all different ones because the VIN numbers are all different. A 2019 Honda TRX, a 2019 Honda motorcycle, a 2019 KTM 790 Duke, a 2019 KTM 390 Duke, a different 2019 KTM 390 Duke. How many trucks did the feds show up with? OMG, we're not even done yet. A 2018 Honda, a 2019 Honda Rebel, a 2018 Honda Rebel, a 2019 motorcycle, a 2019 Honda motorcycle. It's 4 more motorcycles, a Lamborghini Urus, an Audi R8, and then we get to the houses. There are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 52 properties in Philadelphia that are listed. And a lot of them have consecutive house numbers. There are like 15 of them on a Hope Street, which looks like that street that he was filming on. That's how many residences. That's how many residences. That's how many residences. Y'all. When we talk about asset forfeiture, if he is convicted, they will take all of the things that they have listed. All of it. They will take all of it. There are other asset forfeitures in here as to the other defendants. It's not nearly as much. It goes to money and a number of cars, but it's not nearly as much as what we just went through. Oh, it's a lot. And there's a few more vehicles that weren't listed above that are listed here. The Lamborghinis, a few more Mercedes. You guys, that's so much in asset forfeitures. Yeah, that's a lot. We might need a deeper dive, but that's a lot of stuff. That's kind of a crazy indictment. 69 pages and a lot of it's asset forfeiture. Oh my God. We have to get to new Britney stuff, but you guys, I'm fascinated. Those are allegations. He denies it. This is going to be an interesting one to see. I'm going to definitely be following this just because now I'm curious. I mean, that's a lot of houses. The government is going to be auctioning off half of Philadelphia if they take it. Oh my goodness. Are you guys ready to talk about new Britney motions and then Duggar stuff? Are we ready? I'm ready. It's like, we've been talking for like an hour and 50 minutes. You guys are like along for the craziest ride ever. That's insane. I'm going to dig into some of those charges more because I feel like we need a deeper dive. We need lip gloss. We need Britney. That was over 50 houses. Yo. Oh my God. Those are some allegations. The feds are like, okay. Wow. All right. It's time for Britney. There are more Britney documents literally every time I go on to the computer. Today, there was a court order that was issued and entered into the record this afternoon. So we're going to talk about that for a quick second. I'm not even doing a road so far. Y'all know what we're talking about. We don't go to the earlier video this week. It has a decent road so far. If not, go to the podcast next week. It will have a road so far because I've been going through the probate notes in light of the upcoming hearing. And one of the things that is in the probate notes about the upcoming hearing that's very interesting to me is one of the concerns with the appointment of a new conservator of the estate, which is what Britney wants, to yeet her father and appoint somebody new. One of the concerns is that there wasn't enough notice given. So there is a time frame where you have to give a certain amount of notice, 15 days. And they are swapping out the person that they are recommending. So they moved ex parte. That's without the others. Just, hey, Your Honor, can we please have the notice provision waived? And the court granted that motion, which is good news for Britney, because this will not hold up the granting of the motion to yeet James Spears for lack of notice. And it goes through and grants that order. So order on ex parte application for good cause exception to notice hearing for appointment of temporary conservator. You need 5 days notice by overnight or courier. So this is saying, yes, you can give shortened notice. Yes, you can give 5 days notice. That's enough time to give notice today before the hearing on the 29th. So that roadblock that would have stood in potentially in front of the judge ordering or granting the motion to yeet has said, okay, we'll waive the notice provision because look, let's be frank. Everyone knew this was coming. This motion was served with plenty of notice when it was served 2 months ago, a month and a half ago. And this is just the changing out of the name. So this is a good thing. It is a step in the right direction. It is making sure that there are no procedural hurdles to this motion being granted, which on my viewing of the motion to yeet James Spears, the only thing could be procedural because factually, there's nothing there to block this happening. And in the probate notes, it says the motion is okay to grant notice was the question because the motion is legally sound. Those are the PA notes. So I'm encouraged that we are ready to grant the motion to yeet. I'm happy because I think we're moving in the right direction. So aside from that court order today, we also got a new petition to terminate the conservatorship. Oh, I heard you, Fred. You can just come on in. Did you hear him yell? Was it just me? He's back there chatting. Oh, there we are. Hello, darling. Have you been summoned? Is it time to say hello to the Launards and to move my microphone around? Yeah. Oh, and to step on my mouse. Okay. Say hi. Say hi to your adoring public. He has gotten huge, by the way. He is the largest cat. And you're not even a year old yet. Hi, darling. All right, go ahead. He's like, we're here now. All right, let's pull up this motion from David Stevenson, MD, MS, and PhD student, filed in pro per as an amicus brief, which means a friend of the court brief. Where are we going? All right. Fred's having a moment. He's just going to do his thing. The chat says hello, Fred. Fred says hello, chat. So Dr. David Stevenson, who would like to go by Dr. Dave, is a trained medical doctor with 15 years of clinical practice, yet no standing. So, okay. 15 years of clinical practice in emergency rooms and the additional credentials of a Master of Science in Telehealth Health Informatics. Sure. And a PhD student in healthcare services. He has subject matter expertise in the medical and legal aspects of this case. Well, what's your subject matter expertise in the legal aspects of this case? Are we all just internet lawyers now? Does it not matter? Like, I don't pretend to be a doctor. Oh, with peace and love, Dr. Dave, but you don't have standing for this motion. I would like you to explain to me why you have standing for this motion. I think that you just wanted to file it as an amicus just because. I hope you didn't put your personal email on there, but it is what it is. Yeah, has subject matter expertise in the medical and legal aspects of this case and wishes to provide further perspective from a different vantage point. I'm sure that the judge is overwhelmed with joy for the additional perspective. Sure. I'm sure the lawyers are also thrilled. Yep, everybody would like more perspective. Yeah. As the author of this petition, great. If it's you, you've just told us it's you. Why are you speaking about yourself in the third person? As the author of this petition, I rely on the inherent power of this court to excuse his non-legalese style of writing in favor of using creative elements and tongue-in-cheek manner at times. Oh, good. And a typewriter, apparently, or a dot matrix printer, because this is impossible for me to read. But also, you just said a sentence above that you were a subject matter expert in the legal aspects of this case and then want the court to excuse the non-legal style of the writing. I don't understand. One or the other. This fact should not take away from the facts and experts' opinions he is offering. If you've said it's you, just don't talk about yourself in the third person. Okay. There's insufficient evidence that Britney needs a probate conservatorship. Oh, please tell the judge more about how this is an abuse. And it was an abuse of discretion by Judge Getz when the initial order for temporary conservatorship was placed without probing the motives of those individuals initiating the conservatorship. Well, how do you know that wasn't done? You weren't in the room where it happens. The room where it happens. You were not in the room where it happens, and a lot of those documents are sealed. Are you privy to documents that we are not privy to? I am curious. But I also agree that I have big questions about the motives of the persons who initiated the conservatorship. What did they say? Without probing the motives of the individuals initiating the conservatorship, without checking the credentials of the declarant physician doing the capacity evaluation, there isn't a capacity evaluation ever that we've seen. Nobody has seen a capacity evaluation, and multiple things, including the probate notes, indicate that there wasn't one, but okay. And by appointing Mr. Ingham as Britney's lawyer over her personal choice of Mr. Streisand. Well, I agree with that, but Mr. Streisand tried to fight that, and that did not go so well. The last point is argued in other petitions, and nothing further will be added here on that point. Well, great. The physician, okay, but you've already said you're writing it yourself, so no need to write in the third person. Just submit a declaration, which is what you wanted to do. The physician, Dr. James Edward Spar, went outside his area of expertise when making the declaration, to the extent that Dr. Spar is a geriatrician, and his practice is limited to the care of elderly who are the population affected by severe neurodegenerative conditions like dementia. He is an author of journal articles related to the evaluation of mental capacity of individuals. Great. For the proponents of this conservatorship, there's no apparent appreciation for the self-evident fact that Britney is a highly functional, productive artist who belies any claim that she does not have the capacity to make decisions for herself. Well, I think that's the point that we've all gotten to, or at least the court has gotten to, in letting her appoint her own attorney. But the thing is, this has always been a voluntary conservatorship, which raises a whole lot of questions, and I'm sure that Matthew Rosengart is going to be looking into them. According to an authority on the probate code, you've got to cite your sources. Are you the authority on the probate code? Please tell me more. The eligibility criteria is inability to provide basic needs, right? But this is a voluntary conservatorship, which is always confusing, but all right, Dr. Dave. Generally, in the young, severe mental conditions like dementia that would be appropriate for a probate conservatorship are rare and caused by there are no reports of Britney having any neurodegenerative conditions. There are other reasons you can have a conservatorship, but all right. Regarding the ability for Britney to provide basic needs such as physical health, food, clothing, and shelter, she is the embodiment of physical health. I want to know how he knows. Is it from her Instagram account? You cannot just make statements that you do not have personal knowledge of. You do not have personal knowledge of this. There is no personal knowledge. You do not have personal knowledge. How do you think you have personal knowledge? She hires people to prepare her food. Incorrect. False. The conservatorship hires people to prepare her food. And when they are not available, she knows how to drive her Mercedes through the fast food line. Why is this filed in court? And don't shade Britney for her love of fast food. Let the girl go to McDonald's. All right. Her clothes shopping is legendary and can be verified by Versace, Louis Vuitton, and other Rodeo Drive merchants. Nobody in LA wants to go shop on Rodeo Drive. It's a miserable experience and the parking is difficult. She probably goes to the Beverly Center. But did you subpoena them? Because you don't have personal knowledge of that either. The undue influence portion of the probate code is more complicated from a medico-legal standpoint. From Dr. Sparr's most recently published article related to the practitioners making capacity declarations, 3, when the issue is undue influence, he does not believe the treating physician. Why are you citing something that you're not actually citing? Do you what if Dr. Sparr was the one with the agenda, he asks? What he proposes would certainly concentrate the decision-making power into too few hands and could certainly lead to corruption. Possibly he is suggesting that only those qualified to make those decisions would be highly degreed practitioners of both law and medicine that you would find at academic centers, which are places constantly looking for more funding. What? In his academic writing, Dr. Sparr seems to be promoting his own agenda. Isn't that what academic writing is? The printing, the typing on this, the spacing on this makes it so hard for my dyslexic ass to read, because not just the font, but the fact that the font is like spotty makes this exceedingly difficult to read. Fred, stop spinning my mic. In as far as any proclivity to the undue influence by others to the point of being exploited, it is not supported by any facts. Even though Britney lived a life under the microscope, you don't have personal knowledge of any of this. But I do like this. Britney has the reputation of everything she touches turning to gold, not just music either, as she has endorsements for a perfume line that is said to be in the hundreds of millions, even billions of dollars in revenue. In a free society, it's not appropriate for anyone to impose their opinions as to what another individual spends the fruits of their own labor on. Good. Ironically, the only evidence of exploitation to Britney has come about by those who benefited financially from the 13.5-year conservatorship. Sure. I mean, agreed, but you could have written this just in an article. You didn't need to file it with the court. This has been revealed in documentaries such as that featured on Netflix by the New York Times, framing Britney Spears. I know there's a new part tonight. It's so good. Here are some snippets. Yes, we've all heard what she said on the 23rd. This is all just like, hey, I think that that Britney should be free, but this actually doesn't have any legal standing. Here are the harsh conditions imposed during her conservatorship just thus far: social isolation, loss of autonomy, restriction of movement since she was guarded 24/7. We all know this. This reads like a TMZ article formatted like a legal document, and I don't know why the need to file it. One measure of someone's work ethic is the work product. And for Britney, no space. No space. There's no space. That's why this is so hard to read. Her hard work has placed her into the very fabric of the world music scene. On Google, one just needs to type in the first name Britney to get information about her. Great. Thank you for the Britney resume. Britney sings You Better Work, Bitch. It comes from a place she knows well. Never has it been heard by someone standing in line to see Britney, quote, I can't wait to see what Britney's management has done, or I spent all this money because, no space, Jamie is the greatest person and I want to see what he has helped create. No, all of the fans are there to see Britney, period. Yeah. Britney has a loyal fan base of millions. Yes. Reason to terminate the conservatorship. It's never been established why Britney needs one. Yeah, it's a voluntary conservatorship. The treatment of Britney under this unnecessary conservatorship has come at a great cost to her. Yep, agreed. Jody Montgomery and Jamie Spears do not have the best interests of Britney foremost and should be removed. Well, I mean, sure. If Britney insists on having a conservator in her personal and professional capacity, there are plenty of others to fill the role. Card enclosed. Oh, good. There's recommendations. Okay. He included his own references. Oh, and the references. And all of the references. This is fucking odd. This is just odd. This is just odd. It's odd. But it was new. So somebody in the chat said, is he now mansplaining how fans work? Yes. He is mansplaining to the court how having fans work. This is a very strange filing to me. I don't know if we've now had 3. One was from Stan the Stan. We had the one from the other lawyer on Twitter, or who I've seen active on Twitter. I shouldn't just say on Twitter. And then we have this one that is just very odd. It's very odd, but I wanted to share because, I download these things and look at them to see if there's any more information in them. And this is just kind of bizarre. But Dr. David Stevenson is a medical doctor and healthcare consultant in New York, or it was executed in New York. So, but he just as a note, he declared under the laws of California that the foregoing is true and correct and signed it in New York. So it's just all very strange. I don't know why he decided to sign it twice. I like that he signed it #free Britney. You're not pro se, Dr. Stevenson, because you're not really representing anyone. It's interesting again, and somebody just pointed out in the chat, notice that he doesn't sign with MD or PhD, which is very, very interesting. He does not sign his name with his letters, but he put them up at the top, which is, it's just odd. It's just odd. There were other documents filed that we had not gone over yet. They were supplemental petitions, and they were the form petitions to make sure that, one, there was enough time of notice, so the ex parte notice, and then 2, the kind of more formal document to appoint the newer selection for conservator of the estate. I know that we are supposed to see a list of objections to financial documents before the 29th. On the 29th, I will have a podcast episode coming out that goes through the probate notes and what I think will happen on the 29th. I'm going to give you a quick preview. There is the 12th accounting. There's the petition for approval of fees for both Holland and Knight and for Sam Ingham, the petition to remove James Spears, and the petition to terminate the conservatorship. So there's that. What I've seen in a number of the probate notes is that there is reference to, if the removal is okayed, then it's okay to grant it. Once notice is proper, notice is now proper. So I'm seeing in the notes that there is an acknowledgement that all the conditions are met for the removal of James Spears, and that is a very good thing. I am optimistic that James will be removed and everything else will be put over till later. So that is what I'm optimistic about. Okay. That was an interesting one. Thank you for all hanging with me. It's been like an hour and 30 minutes. There are over 4,000 of you in the chat. And I should say, to do the YouTubey things, the like and subscribing things, we're about to bing again, which is great. We're at like 156,000. Emily has set the desire to reach 200K by the end of 2021. So that is my goal. And yeah. Cheers. Who's ready for some Duggar stuff? Are we ready for some Duggar stuff? Let's talk about head, shoulders, knees, and toes and stuff. Duggar stuff. Josh Duggar's attorneys filed 4 motions, and these are replies to the government oppositions to their previously filed motions. These are all set to be heard on Monday, which will be very interesting. So we're going to hear what the judge has to say or arguments from the attorneys on Monday, or the judge might just rule on them on Monday, which is totally possible. Fred, I swear, you can't just walk on the keyboard though. He's like, I do what I want. I do what I want. Are we done? Yeah? Okay. I can't pull up documents if you are standing on the keyboard. Yep. Fred's like, no, we're over it. We're over live streaming and we just want to play. Let us pull up the first one, which is the defendant's reply in support of the motion to dismiss indictment for violation of the appointments clause. Look, you know how I feel about the appointments clause argument. I appreciate the novelty of the argument. The government made a very good point in essence that if there is a violation of the constitutional appointments clause in Department of Homeland Security, that it doesn't affect the statutory authority of the feds to do their job and investigate the Duggar case, that they still have statutory authority, even if there is an issue. And the government had a lengthy response, which then garnered a 17-page response from Duggar's attorneys. I am going to have to just dig into the law of all of this and give you a breakdown on just these appointments clause motions, because they're legally fascinating, but factually, it's like, nothing's going to come of it. The court's not going to grant it because, again, the agents do have statutory authority, even if the head of the department violated the appointments clause and it went out of order to appoint someone. So it's not going to fly. I appreciate that they tried. So, are you just going to eat my microphone? Is that what we're doing now? Fred is having all of a moment. So yeah, we're going for the first paragraph and then we are definitely moving on. What stands out is the government's response. What stands out about the government's response is its deafening silence regarding the legal authority directly on point regarding the government's position, rejecting the government's position. Even though Duggar relied extensively on the August 14th, 2020 decision published by the nonpartisan United States Government Accountability Office and on the United States District Court for the District of Maryland's decision in Casa de Maryland versus Wolf, both of which expressly found that Chad Wolf and Kevin McAllen, we're going with that, held the position of acting Secretary of Homeland Security without lawful authority. The government fails to even address, let alone meaningfully engage with this authority. No, they don't have to. They say that there is statutory authority, and then they get into why it was proper. So, yeah, they say that the government has no meaningful response to offer. They did offer a response. They didn't address that. So this is going to be them going back and forth over legal authority. Again, I would be shocked if any of this flies. It's not going to. Let's see what they ask for at the end of their motion. Are we going through this whole motion? No. Does it get its own breakdown? Yeah, maybe. Just on the legal aspects of it. But today we want to get to hands head, shoulders, knees, and toes, and the statements, because those were the juiciest government responses. So I think those will be the most interesting defense replies to government objections. Based on the foregoing and the arguments set out in the motion, this court should dismiss the indictment and grant other such relief. Yep. Dismiss the whole thing, Your Honor. They didn't follow their own order of succession properly, but they don't get around the fact that there is statutory authority outside of the order of succession, and that is going to be their problem. So I think the appointments clause argument will not fly. I think the court will just deny the motion. I don't know if the court will get into a lot of reasoning, but I'd be interested to see if the court does get into a lot of reasoning. I will be very surprised if it flies. This is the defendant's reply in support of the motion to suppress statements. This is one of the most interesting one, this one in the hands and feet, because this motion from Duggar was basically that he was denied an attorney, that he was improperly interviewed, and the government said, no, he wasn't. And by the way, when we asked him if he wanted to talk, he said yes. He waived his Miranda rights. He wasn't under arrest. There wasn't even an arrest warrant. And then he kind of looked around and said, was somebody downloading child pornography? Huh. So weird, because of course that's the first question you ask the feds. So I don't think that this will fly either, but let's get into what the defense responded, because we went through the government's opposition quite a bit. Hi. The government's response ultimately boils down to this. First, Duggar did not unequivocally invoke his right to counsel by physically taking out his phone and communicating to law enforcement that he was attempting to make contact with his attorney before law enforcement physically took his phone out of his hand to prevent him from speaking with counsel. Well, yes, because you can't invoke the right to talk to counsel when you're not being interviewed. Second, Duggar was not in custody when law enforcement approached him. Accurate. Escorted him to a law enforcement vehicle and interrogated him without counsel present. Well, they asked him if they could talk to him, and he said, yes. Yes, they did. Second, Duggar was not, we did that one. Third, Duggar consented to the interrogation, questioning, without any use of strong arm tactics or deceptive strategies. They're allowed to use deceptive strategies, by the way, by law enforcement, despite having earlier asserted his constitutional right to counsel, only to have law enforcement physically stop him from exercising that right. He had access to other phones. And you can't initiate your right to counsel if you're not being interviewed. And when they showed up to search the place, he wasn't being interviewed. As will be set out at the evidentiary hearing, which is what's happening on Monday, Duggar not only unequivocally invoked his right to counsel, but attempted to speak with counsel and was physically stopped from doing so by law enforcement. I don't think this will fly either, but I think they have the strongest argument on this. I just don't think it's going to fly. He was not in custody. He was not being interviewed when he said, oh, I want to let my lawyer know, like, that the feds are here serving search warrants, and they didn't stop him from using other phones. There are lots of valid law enforcement reasons that I've previously talked about why once you have a search warrant for a phone, a computer, and digital evidence of crimes, any digital evidence of crimes, they take your phone first so that you can't kill switch anything. I mean, that is what happens. So I'm not surprised. Also, I really want to know if there was a landline anywhere, because I bet that there was. Fred is literally just like, you cannot see him, but he is the length of my desk. Oh, I stopped petting. I'm sorry. I've stopped petting and I got a look. It was like, no, we're not done yet. All right. Duggar unequivocally invoked his right to counsel. Disagreed, because when they gave him a Miranda waiver, and said, would you like to speak to us? And he was like, is somebody downloading CP? Sure, I'll speak to you. And then proceeded to spoke to them and ask them things like, is my IP address marked? So this is a rehash of the argument that they made in their previous motion. So we'll see. They go through the government's case authority and try to distinguish the case authority, saying in that case, this happened. In this case, this is happening. They talk about the government relying on Ninth Circuit opinions, which is fair because the Ninth Circuit is not controlling in Arkansas. It's controlling in the West. The police-initiated interrogation was custodial. Hard disagree, but they are saying that In response, the government correctly acknowledges that when taking and considering evidence in this issue, the determination of whether an interrogation was custodial is an objective standard. And then they cite the same case, Stansbury versus California. They say that the government relies on an apposite legal authority in support of its contention that the interrogation was not custodial. And then they go through and try to distinguish the government's evidence. They say that the evidence that the interrogation was custodial is abundant. The very first action law enforcement took upon arriving on scene was to physically stop Duggar from exercising his constitutional right to speak to his attorney. His constitutional right hadn't attached yet. You don't just walk. Okay. They're doing their best. I disagree with their arguments. I actually do think. Oh, and I haven't pulled up the thing. I'm sorry, y'all. Apologies. His right hadn't attached yet. I think his lawyers have done a very good job in their law and motion. They have made good arguments. They have done good legal work. They are on the downward slope with the Sisyphean task of pushing the boulder up the hill. And they are doing a very good job for their client, Josh Duggar. I don't think it is going to fly. So me saying, no, I don't agree is just me not agreeing with their position, but they have made their arguments well. I think that they have quite a lot of room to argue on this one. I don't think it's going to fly. I don't think his right attached yet, but I think they've done a good job in these motions. So when I get frustrated, be clear that it is not with the legal work here. It is just with the arguments. I disagree their position. They're stuck with the timing that they're stuck with, and they're doing the best they can with facts that are in all reality against Josh Duggar in this case. And when the facts are against you, you try to throw out as much of the evidence as you can. And that's what they're doing. They are doing their job, and they are doing a good job at it with what they have. Just with what they have, I don't think they're going to win on these motions. Fred is just loving the microphone this evening and is going to keep knocking into it. All right, fine. Just keep rubbing your face on it. We'll just hold it. They say, finally, the government takes issue with Duggar's characterization that he was escorted to the law enforcement vehicle, apparently implying that it was Duggar's idea to sit inside the law enforcement vehicle with 2 armed federal agents. That's not what was said. That is a very broad reading of what the government said. Look, you don't get to just change what the government said. What the government said was, we asked him to go sit in the car. It was probably hot and they wanted to go sit in the air conditioning. Also, they wanted to have somewhere private to go talk to him if there were other people still searching the lot where they could hear him. So when they say, they're like, hey, we're going to go sit in the car and talk. Would you want to talk to us? He could have said no and not gotten into the car, which the defense completely fails to mention. But it'll be interesting if that comes up at the evidentiary hearing, depending on what the court hears, because the court has granted a hearing for Monday. They say that Duggar did not knowingly and voluntarily waive his Miranda rights. I imagine that they're going to play the audio of him waiving his Miranda rights, which is, the court's going to go, well, that sounds like you're not coerced. And the court will listen to the recording and listen to the tone, listen to the way that it's discussed, and then decide. There's no dispute between the parties that waivers of constitutional rights must only be voluntary, but be knowing. We know. To that end, when Duggar waived his Miranda rights, whether he waived his Miranda rights is a red herring because he'd already invoked his right to counsel. No. His right to counsel didn't attach yet because they weren't talking to him yet. He was not. It attaches at a custodial interrogation. This was not a custodial interrogation. And when they said, we have a search warrant, and he said, I want to talk to my lawyers, they said, hey, by the way, we get to keep your phone. He could go use another phone. I disagree, but it's the only argument they have on this, but I just disagree. So they're saying it doesn't matter. It doesn't matter that he waived his Miranda rights because he already asked for a right to counsel. So if your right to counsel has attached and you say, and they ask you anything more, then everything else is invalid, but his right to counsel hadn't attached yet. So this motion, I don't think will win. They say, but even if this court, I love a good arguendo, even if this court turns to the issue of whether there was a knowing and voluntary waiver, there was not, especially when this court indulges in every reasonable presumption against waiver. Remarkably, this analysis will require the court to look at two separate inquiries. First, how much Fred wants to be held right now? And get fur in my lip gloss. First, the question law enforcement claims Duggar asked before the recording equipment was turned on, and second, the statements Duggar allegedly made after the recording equipment was turned on. This is because to the extent the Miranda form means anything at all, it was not even allegedly signed until after the recording equipment was turned on. Right, because the first thing Duggar asked them was, has somebody been downloading CP? So I appreciate their argument, because if they can get the first thing kicked out, if we can just get that first statement that seems like it'll be argued as an admission of guilt, if we can just get that first statement thrown out, maybe we're in a better position than we are if we don't get that first statement. Are you turning up the brightness on my computer now? And walking on the keyboard. We're just professionals here. Cats everywhere. Cats and dogs. No, just cats. Just cats. Turning up the brightness on our computer. Huh. Floof. All right. Let's get to the conclusion, and then we'll move on to head, shoulders, knees, and toes. As already set out on the record before this court, and as will further be established at the evidentiary hearing, Duggar unequivocally invoked his right to counsel by taking out his phone and communicating to law enforcement he was attempting to make contact with his attorney before law enforcement physically took his phone out of his hand before he could speak with counsel. Furthermore, law enforcement approached him, escorted him to a law enforcement vehicle, and interrogated him without counsel present. The circumstances were such where a reasonable person would conclude that his freedom of action had been deprived. He didn't have to get in the car, especially having already asserted a constitutional right that was completely ignored because it wasn't attached yet. And finally, Duggar did not knowingly and voluntarily waive his rights. As such, his statements should be suppressed. I bet they want his statements to be suppressed. It's not going to happen, but they've done a good job trying to make it happen. I mean, what else can you do other than try to get that statement out? Because what the feds have told us is that the first thing he said was, "Oh, hi, the feds are searching my workplace. Is somebody downloading CP?" It's funny that his first thought was not, "Oh, have I been defrauded? Are there financial crimes going on at my car lot?" No, that was not his first thought. And that is why they want those statements thrown out, because those statements are very difficult to overcome at trial, because the prosecution will hammer them over and over and over as an admission of guilt. So how did he know? Oh, because he did it. That's how he knew. That's how he knew to ask that question, because he was aware of what was going on, because he was the one doing it. That is what they will argue. All right, let's get into motion number 3. Defendant's reply in support of defendant's motion to suppress photograph of heads, shoulders, knees, and toes. It's just hand and feet. Head, shoulders, knees, and toes while in custody. What stands out about the government's response is that the government does not dispute that federal law enforcement required Duggar to physically pose for the photographs giving rise to this motion, or that the photographs depict Duggar's hands and feet from atypical angles. This matters because, as the Eighth Circuit presupposed in the case law most directly on point, photographs of this nature require a warrant. The photographs were evidence gathering during the execution of a valid search warrant. This is the one that will be most interesting to me. I could see the court saying, you know what, this is looking for a specific scar on his hands to show, I think what they will use it to show is that the phone belonged to him, because there are things on the phone that identify him, and that scar on his hand identifies him on the phone. So I could see them kind of fighting this one out. They know better than any of us do what the government's trying to prove, because they have this evidence too. So it'll be very interesting to see what the court does on this one. Of all of the motions, this is the one I'm most interested in, because I think this one gives the court some wiggle room to say, you know what, there are times, particularly if you're having someone take off a shirt and photographing tattoos or things, there are definitely times when you need a warrant for that. So it'll be very, very interesting for me to see. I am covering cat here. To see what the court does with this. I think that because they got consent, the court could still say, you know what, you needed a warrant because you're using it for evidentiary purposes, or the court could say, no, your hands are in plain sight. You didn't have to remove any clothing. You didn't have to do anything unusual. You just had to put your hands out and have a photo taken similar to a booking photo. And that is not where a warrant is required. I'm very, very interesting. I'm not very, very interesting. I'm very, very interested to see what the court does on this one. I think the defense has made really good arguments here. I don't know. I'm mixed on this one. I could really see it going either way. It's going to depend on the court, and it's going to depend on what they talk about. So I think the plain sight might overrule the atypical angle, like the hands being put on the table. The court should reject the government's justification in its response as non-compelling post hoc rationalization. In response, the government attempts to downplay the constitutional significance of Duggar's motion by asserting that photographs document a scar on the defendant's hand. But this explanation does not comport with the actual photos. In stark contrast, the photos show both hands, not one hand. Well, you can't, I think it would be stranger to take just one hand. And the photographs document different angles of both hands with different levels of zoom from different vantage points. If the government really sought to document one scar on one hand, a single photograph of a single hand would have sufficed without requiring Duggar to pose for different hand positions, without requiring his feet to be positioned in a specific manner. I don't know if his feet are positioned in a specific manner or just standing there. But what is more troubling about the government's after-the-fact rationalization is that the agent taking the photographs presumably had to stand behind Duggar and reach over his shoulder to obtain the angle reflected in the photographs. It is this combination of the manipulation by federal agents of Duggar's body, the awkward angles, and the depiction of Duggar's feet along with hands, and the photographs of both hands that disprove the government's assertion. That'll be interesting. Under the Fourth Amendment, the government was required to obtain a warrant. Taking pictures of body parts in plain view, as the government asserts, does not require a warrant and would not require federal law enforcement to manipulate an in-custody defendant's body parts. So they're saying it's not plain view because we're making you put it this way, which is interesting. Very interesting. It is no surprise that the government made no mention of its intentions to Duggar in the presence of his attorney during the self-surrender process. Rather, the government simply produced these photographs in discovery with no explanation or context. Well, that doesn't surprise me at all. Here's photos that we took. Here's the booking photos. They go on to argue that the government misplaces its reliance on the cases it cites and attempts to move the ball away from the clearly delineated Eighth Circuit precedent regarding photographs of hand. What did you take out of that sentence? Put the whole sentence in there when you cite it. Photographs of, maybe it's just other body parts and then hands under a valid search warrant under Merrill. Faced with the legal authority directly on point, the government instead asked the court to focus on cases that address photographs of a chest and voice identification. Well, voice identification is not in plain sight. You have to compel someone to speak, which they have a right to not do. Indeed, a single case cited by the government, which relates to photographing body parts without a warrant or consent, is a district court case that can be easily distinguished from the issue now pending before this court. And then they go on to distinguish the case law in their view. And this is, again, two sides of the same coin. I see this court meaning this, or this law meaning this. I see this other law meaning that. They say law enforcement violated Duggar's Sixth Amendment rights because counsel was not present when the photographs were taken. I don't think counsel has to be present. They asked his permission. It's a good, you're going to make an argument, fine, but I think the stronger arguments, the first one, which is probably why they made it first. Conclusion, based on the foregoing, this court should suppress photographs. I want to know what else they know, because they now know, the defense knows what was on his phone. I want to know what else was on his phone that they are so worried about with these photographs. I think because, again, the government has to prove that Duggar was the one at the keyboard at the time things were downloading and uploading. So if he's showing, like, if there's photos of him pointing at cars on the lot with his hand, and that photo of a car on the lot with the price or something is GPSed to the car lot at the same like realm of time when stuff was going on the computer and there was no one else working at the lot, then you're going to be like, look, this photo shows he's there. It's on his phone. So it's very interesting to see how these will be used and what the court decides to do with this particular motion and why we're fighting it, because they're definitely fighting it. It might just be we're fighting everything, screw it, appointments clause. Like clearly we're just fighting everything, throw it up against the wall and see what sticks. Or it might be something more specific than that, that there is one thing, one piece of evidence that they are trying to knock out of the chain of identification. And I would love to know what that is. And if this motion is denied and this goes to trial, then we will see. But he still has the opportunity to plead before the end of October. So if he loses all these motions, you might see a change of plea in this case. There's one more to get to, and that's regarding the preservation of evidence that the government doesn't possess. So they're saying they can't preserve what they do not have, which is, you can't preserve that which you do not have. I really like the defense's writing. I've liked the government's writing in this case. I think the lawyering in this case has been really excellent, but I like how clear and concise they are with their IRAC format. It's just such a nice change of pace from some of the trillery brownie bullshit that we've read on this channel in the last year. It's nice to have the issue, rule, analysis, or argument and conclusion. It's just so nice. It's so nice. The evidence obtained but not preserved by the government was potentially exculpatory. This is regarding cell phones of other individuals that were questioned, and they looked at the cell phone and were like, there's not a tour, there's not a this, there's not a that. This phone doesn't have anything on it. And then they didn't do a forensic analysis. They didn't do a detailed sweep of the phone. They just did a visual inspection and were like, we good. And the defense is saying, right, but that phone might have had evidence that we needed to show that these other people were at the lot and these other people were the ones who potentially had access to the computer. Because remember, the defense doesn't have to prove, as I pulled the document back up and then continued to sidebar, the defense does not have to prove that it was someone else. They don't have to prove it was this guy or that person or this woman. They just have to prove it could have been someone other than Duggar. It could have been this guy, it could have been that guy, it could have been somebody else, who knows? And if it's a who knows, then it's not beyond a reasonable doubt. They just have to instill doubt if this gets to a jury. The government has to prove identity. They have to instill doubt. And so that's what they're trying to do. Could be lunch meat, could be peaches. Who knows? Who knows? So they say in its response, the government, for the first time in its entire litigation, takes the position that a search of an electronic device can be performed quickly and easily in the field. I mean, it's a fair statement. In stark contrast, in the affidavits submitted when law enforcement sought search warrants in the case, HSI special agents explained in great detail that searching computerized information for evidence of a crime often requires special agents to seize most or all of a computer system, central process, the CPU, input and output peripherals, related software, documentation, data, including passwords, so that a qualified expert can accurately retrieve the system's data in a laboratory or other controlled environment. Well, yes. But that's not the beginning of it. They're talking about their initial peak. It is a well-made argument that if you need all this detailed forensics, how can you even have an initial peak? Like, is it a look-see or not? They say, nonetheless, when it comes to electronic devices that do not allegedly belong to Duggar and or Hosel motor cars, law enforcement actions and the government's response makes clear that a manual review of two witnesses' cell phones and a forensic review of another witness's cell phone in the field was sufficient. The government offers no explanation for this glaring inconsistency. Okay. While the government asserts that it did not seize the cell phones belonging to these three individuals and that the government cannot preserve what it does not have, the government had no obligation to take investigative steps based on what the defendant might want at some time later. The evidence that the evidence and the government's response tells a different story. The government did seize the three phones, and law enforcement performed at least one forensic analysis of the phones. That's not quite what I remember from the government's motion. It said that they asked if they could see the phone and looked at the phones. It did. They're calling that a seizure. I don't think the court's going to find that to be a seizure. That is standard law enforcement procedure. The evidence reveals and the government's response makes clear that the three individual cell phones were seized. They acknowledge that law enforcement manually reviewed witness three's cell phone, but apparently opted not to use a forensic tool and found no evidence of criminal activity on it and returned the device to the individual. And the government notes with respect to witness one that law enforcement did the very same thing. However, with respect to witness two, the government cryptically explains that rather than manually reviewing his cell phone, witness two allowed law enforcement to examine his cell phone during the interview. Law enforcement observed no evidence of CSAM during this examination and returned the device to the individual afterwards. Law enforcement did not create a forensic report or forensic image of the device. However, later in the government response, the government clarifies for the first time that with respect to witness two, the examination consisted of a forensic review, which uncovered no evidence of CSAM and did not result in the creation of a forensic report. I think that the court is going to not agree with the defense on this, but the defense is pointing out some fair inconsistencies. And I think that goes a long way for them to be able to argue, maybe to allow a jury instruction or potentially tell the jury, look, again, they only need to create doubt to say, look, the government should have preserved these things and we could have asked them and they didn't. But those witnesses might also come in and testify, and then that argument's kind of dead in the water. I think, again, they are fighting to find any foothold they can to get some of this evidence removed and not potentially being seen in trial, or not being allowed in trial. And that will give them a better position to determine if he's going to take a plea deal or take this through to trial. So they go through the inconsistencies. They go through differentiating the case law. They talk about the fact that if a report was generated by the forensic review, which assuredly there was, Duggar's been deprived of the ability to use it in the event witness two testifies at trial. I think it'll be like, hey, we have the opportunity to talk to him, but that's about it. The government's failure to preserve constitutes bad faith. They're saying the government should have known. The government should have preserved this evidence. It's bad faith. We get a jury instruction or we get things thrown out. Comparable evidence is not available. That's true. They can't just recreate what somebody's cell phone looked like 2 years ago. Based on the foregoing, the court should dismiss this case based on the government's failure to preserve. Just dismiss the whole thing. I don't think that's going to happen, but that's what they're asking for. So those are the latest. The Monday court date is an evidentiary hearing with regard to these motions. I think they're only going to do evidence with regard to the statements and the circumstances surrounding those statements. But let me pull up the docket real quick just to be sure, and then we will get into questions. I know it's been over 2 hours. We got through a lot. I was not anticipating spending quite so much time going through that 69-page. I was going to talk about the article and then go through it a little, and then I saw all of the asset forfeitures, and I just got curious in the moment, and y'all came along for that ride with me, and I think we're all better for it. Because now we know that the true mark of a successful YouTuber is over 52 different homes. I mean, I feel like I would always have late payments, and that would be terrible to try to organize, but it's sure fascinating, and that case is going to be the Omi in a Hellcat case is going to be very, very interesting. Let me pull up. Duggar, where are you hiding in my long list of cases that I'm tracking on Pacer? All right. We're going to just pull it up together. The Frank's hearing motion. We didn't pull that one up because that one came in late. Well, we're not doing it today. It's too late. I don't care. They added a supplemental affidavit. They're going to want a Frank's hearing. The court is having a hearing on Monday. Let's see. Here's the text only order. Text only order resetting motion hearing to 9:27 at 9:30. And then text only order motion to continue hearing. The hearing will be reset by a separate order. So that's the hearing for Monday. That's going to be kind of the omnibus hearing of all of the motions that are pending. And that gave them time to file all the responses, and the government will have to respond to them. But yeah, so that's what's going on Monday. The trial date still stands, which is, I have it noted down somewhere, November, December, January-ish. It was in a motion that we covered ages ago, and I just don't remember, and I don't have it in my notes that I have pulled up. So that is the end of that. We need to get to questions real quick, and then I have got to go. There's more Britney stuff on tonight. For those of you that were with me on Instagram last night, I'm still not all the way done recording next week's podcast. So that has to be done. But let us get to questions. I have questions. You have questions. We have questions about any of the things that I covered tonight. I covered so much that it's going to be hard to yeah, there was so much. Anyway, thank you so much, Law Nerds, for being respectful. I forgot to totally do a trigger warning with regard to Josh Duggar. I know there are strong feelings about this case. Again, innocent till proven guilty. There is, what we've seen is a substantial amount of evidence in this case. I think that with a substantial amount of evidence in this case, they are doing a good job trying to parse through the different pieces of evidence that they might be able to get thrown out. And that's their job as defense attorneys. And I think they've actually argued really well. I think the evidence is against them, but they've been arguing it well. So let's get to as many questions as we can. And thank you all for being kind and respectful in the chat. You know, it's why we have the best chat on the internet. Fred agrees. Fred agrees with me. Question regarding the Petito case. Could there be an issue with capital one being spelled wrong in the first instance in the indictment? Would they try to pull that it's not pled properly? No, generally not. I didn't even look. Again, dyslexic. I don't catch misspellings all the time. Only sometimes. But I did not notice that at all. But it generally, because they included the account, it's not going to be seen as a fatal defect, essentially. So even if it is spelled, and I would pull it back up if Fred would stop standing on my keyboard. Thanks, Fred. Oh, you've made it very large, buddy. Thanks for the help. He's like, but I'm helping so we can see it. I didn't even look. Yeah, I don't think it's not going to be a fatal issue because they've got the account numbers ending. But yes, there are definitely typos in this. They got the wrong section number. This is what happens when people move fast. They've got the wrong subsection number here and in the press release. It's just, again, fast moving. It doesn't look great, right? It just doesn't look great. Do we know if the Duggar kids have been interviewed yet? No, I have not seen another word about it. It was only mentioned in the detention hearing. It has not been mentioned in any legal documents that I have seen. That doesn't mean it hasn't happened. That just means that we don't know if that has happened. So question, are there laws that protect prosecutors from defamation suits regarding the cases they are prosecuting? Yes, immunity. Prosecutors generally have immunity when they are acting in the course of their work. So, yeah. When and if Duggar is convicted, how much jail time do you think he would have to do? Oh, I would need to look at his max again. It was discussed, and we talked about it in the plea deal documents about how, about the range they were offering. And I think they were looking at like a 10-ish year range in the last documents we were looking at, but I don't have that off the top of my head. But on 2 counts, I mean, after trial, I think in that there kind of is previous history, which is a thing. in that 5-10 year range is not unreasonable. So that wouldn't surprise me. So I am going to swoop and get to some of the super chats that I missed while I was talking away. Thank you all for your super chats. Can they charge Laundrie with theft of the vehicle since now they have a timeline? We talked about that really early on about why I didn't think so, and why it would be harder to do. They don't have, well, unfortunately, they don't have anyone to say he didn't have permission to drive it. It was never reported stolen, and that's going to make things more difficult because Gabby was technically the owner, but they were both living there. The charges that they have now are easier. Whether that could come down the line with more evidence, possibly, but they went for the easy charge, and we can see that they're moving quickly in this investigation and still trying to find him. So that's kind of where we are. If only the Girardis had that many assets, love you most says, yes, if only the Girardis had 52 houses, everyone would get paid. I appreciate that super chat. I'm trying to get all the way back to the beginning. I love this infinite scroll because I love pulling up your super chats and seeing them. But we were busy tonight and we still have over 4,000 of you here, which is a perfect time to say, do the YouTubey things. And if you don't follow me on social, I'm at the Emily D. Baker if you would like to, on Instagram and on Instagram and on Twitter, and of course on Patreon at Law Nerds Unite. What is the difference between motive and intent? Can you give an example? Oh, Amy's asking me the hard questions today at the end of a long stream. It depends on context, truly. Intent can go to what is required for the crime, generally specific intent, general intent. It's to a level of the crime, improving the mind state. Motive is why somebody did something. So like a general intent crime would be, assault with a deadly weapon with like a car. You have to intend to drive the car. You don't always have to intend to hit the person, where specific intent murder means you specifically intended to do the thing and kill the person. So that is legally when we're talking about intent. It is intent for the crime. Motive would be the reasoning, like the mindset reasoning behind doing the crime. Hopefully that makes sense. That is a rough explanation at the end. Law professors everywhere are like, no, this is 3 hours worth of information and we need to delve into it deeper. No, we're not. All right. I'm going to try to get to the motion for I Just cups and shirts. I mean, motion granted, I think it's fantastic. We absolutely should. Thank you to the mods who kept up with all of the super chats so I can get to them and get to as many as I can. Millennial Money asked, think Josh will get 10 years and take the plea deal? I think he's going to wait until he sees how these motions shake out. Tabby said Jim Bob needs to save money for Josh's jail commissary. We'll see. I mean, they're definitely spending a good bit of money on lawyers' fees, I'm sure, but they are seeing this as money well spent. If you can get some of that really damaging evidence that we've already heard about out, the jury will never hear it. And that can go a long way in a trial. Or again, all the defense has to do is show doubt. And there are times that it is a wonder to me that anyone is convicted at all, because, when do you not have doubt? The evidence has to be overwhelming, and they're going to be in a computer crime fighting not just to show the evidence, but fighting to show that it's him. So that'll be interesting. Abby says, I'm in Texas and my friend Caitlin is in Maine and we are watching you together. Yay! Thanks for explaining everything to us to understand. Hi, Caitlin. Well, hello to Caitlin and Abby for watching, even though states away, together. Good to see you both. Maria V said, day of moving out of my 4th floor walk-up apartment. That's got to be a lot. Boyfriend or BF could be boyfriend or best friend, got us pizza and just remembered it's Friday night. Emily, life is so good. Yay. Yay, yay, yay. Sean said, we are absolutely blaming you for the Twilight references, though, lawyered. I mean, it's totally fair. Cindy Thomas sent a super sticker. Thank you. Motion for I Just cups. We got that. T-Light said, I may have missed it, but did you talk about how the Laundrie parents could avoid aiding and abetting? I definitely didn't talk about how anybody could avoid aiding and abetting. Those are kind of like facts. It either happened or it didn't. They could have aided and abetted before the fact or after the fact. They could potentially obstruct justice if they know where he is and are not helping. There's a lot of coulds and maybes, and it depends in there. And until we have more facts, we just don't know. Once we have more facts, if I have facts to say this is what I think could go down, then I will. But right now it's like, if this, then that, but if this, then that, but if this, then this other thing, but if this, then that other thing. And that becomes really difficult. Aunt Cecilia said she should launch a clothing line called My Fabulous Dresses and market it as a clothing line designed by Hayley Paige. She cannot market anything as designed by Hayley Paige until this is resolved based on the nature of the preliminary injunction. But down the road, she can use Hayley Paige for things that are not evening wear and bridal and things that don't compete with JLM. So it will be hard for her to use her name with design if she does dresses. Swing on Down said, can the police track Laundrie's cell phone? He definitely updated different social media accounts since all of this began. Yes, they can triangulate the cell phone if he was using his cell phone. If he stopped using his cell phone and got a different phone or a different method of communication, it becomes harder. But also, without being instructive, there are ways to track where social media postings are made. And that just takes some time. Facebook and Instagram can be really slow on responding with some of those things. There is a acquaintance ages and ages ago that ended up being killed and was tracked down by their iPod. And it took a while she was unidentified for a bit of time because she didn't have ID on her and was a missing person. But when they were able to get into the iPod, they were able to track it back to the iTunes to identify her. God, that was so long ago, before anyone would have had a cell phone in their pocket, when we were just running around with iPods. But it takes time to get the proper authority and the proper warrants and stuff to do that. You can't just be like, hey, Facebook, can you tell us where the GPS location of all these posts came from? I mean, they can if you subpoena them, but they don't just tell you. So Swing on Down, thank you for the question. Sean Vantal asked Emily, how do you feel about the sensationalization of the white woman syndrome? Do you think that you are playing into it? What can be done to combat? I really don't know enough to answer. I think that the reason that the Gabby Petito case has kind of taken hold on social media is, one, the facts are kind of in the sensationalized category. Two people go out on a trip, one person comes back. The lawyering up immediately and not speaking to police definitely makes it a case that the national media is very interested in. I think that because she's a social media personality, people, I don't want to sound crass saying it, but there isn't any other way to say it, but people like to kind of onlooker from home. And when somebody is very active on social media, it's easy to go through and look at old videos, look at interactions, look at old postings, and start to try to connect the dots for yourself. So it has a different element of people trying to almost play along or solve along at home, which is one of the things we like about some of the cases we follow, right? With this Amia in a Hellcat case, we can go look at the videos with the cars and the houses and some of the comments about this case. You can almost watch this lawsuit along at home. It's one of the things that I think was so fascinating for a lot of the internet about the Toddy Westbrook KJ case, is that one party was talking so much on social media and people were like, you were involved in it in real time. It's why people are sucked in to Housewives, both in Salt Lake City and in Beverly Hills. We're watching people react in real time to things that are criminal, and things that are legal, and things that we've seen play out in the legal system. And so I think a lot of those factors play in. I think when people don't have large social media presences, there's not as much to dig into. The facts aren't as new and different. And as cases get older, people do tend to lose interest, except for the prosecutors and investigators, family members, and those that are really involved in it. So hopefully that helps. Do I think I'm playing into it? I mean, I don't know. I hope to be helpful. I always am mindful in the content that I put out. I don't always say things the right way. I don't always do things the right way, but I want to help foster understanding of our legal system, not exploitation of cases. And I always try to evaluate that for myself when I am covering cases, which is why I tend to stick to covering things that have documents that are being filed in court. And and not things that are open quite like this. I just thought there was a lot of misunderstanding and a lot of misreporting on the Petito case. And I think that my experience as a district attorney and then my own personal experience with families going through this kind of put me in a position where I could give some comment that might be useful in some way as everyone's trying to understand. Hopefully that makes sense. M. Barron said, saw DMB on Wednesday. Ooh, that was a good set list. You got a good show. And thought of you might have been my best Dave show to date. Yeah, that was a really good show. Love your Friday Night Lives. Best treat after a long week of work. Well, thank you. And I'm going to get to just a few more questions, and then we are going to have to roll out. Roll out. Roll out. But thank you guys for sitting through me. I know that I will not be able to get to all the super chats every week. I really do try my best. And it's just, it's not always possible. It's a lot of questions. It's only so much time. And I put too many cases into Friday nights. I'm going to have to put less cases in, not next week, because next week I will be traveling and I will be at Vid Summit with, Mr. Beast and Mark Rober, who I'm super geeked about, and Laserbeam, and our friend of the channel Viper, and Roberto Blake, and Christina Smallhorn, and so many other amazing creators. And I'm going to be in like YouTube La La Land next Friday. So now I've got to scroll all the way. Oh, wait, no, it does it for me. Yay. KD said, Emily, I appreciate that you gave info on a recent live about a lesser known missing person of color. The geologist who's missing, I think that helps combat missing white woman syndrome. And again, there are things I just don't know about that I try to do my best with, but we absolutely, there are so many factors in this case that are that play into it. And I also think the relational aspect of the case absolutely plays into it for a lot of people. So the relational aspect, I think, plays a big part of it. So Katie says, well, I think that is some truth to it. This specific case is so bizarre and plays like a Lifetime movie, and it draws people in. It does. And the media definitely is pulling at that. So let's see. I'm going to get to just a few more questions, and then we're going to move on. Just said you this one, Megan. We're here. Hi. Don't forget to like and subscribe. Statement, even the Victorians had sensationalized crime media. I mean, people are fascinated by things that they don't always understand. And I think that's where true crime draws a large audience of people who are just fascinated by the stories, fascinated by the facts. And then with social media, you see it play out almost in real time. It's very different. And I think it would be very difficult to be prosecuting now with how much information there is from social. I mean, I prosecuted using social media, like even MySpace, but it's social media in 2010 is just so different from social media in 2021. It's very, very interesting. Mother Oats, good to see you. Question, do you think this will spur some people to make Facebook have a department that helps with missing people on Facebook? I don't know that they don't. I'm sure they have a law enforcement relations department. I know they have a department that responds to search warrants. I don't know if they have one regard to missing persons, but I'm sure they have units that deal with that. I just don't know if they have enough people in them. Question in regard to the manhunt for Brian Laundrie, is there a timeline for how long the police are allowed to use this many resources? That's up to them. Like after a month, they just stop. That's really up to the department. It's going to be up to the FBI, whether the warrant just remains open. I mean, I had cases, one that comes to mind first, top of mind, the warrant was out for 12 years. Finding witnesses was a whole another story, but the warrant was open for 12 years before they picked the person up and brought them in. Warrants can be out warrants can stay open until somebody is found, but the manhunt aspect of it and the searching of the reserve that they're in now, I'm sure they internally have some cutoff where that will stop, and they will need to redirect resources within their own community. So hopefully that helps. Catnip tip because I saw Fuzzy Pondered butt earlier. I mean, he definitely showed his whole butt on stream, didn't he? Kay said, I had a relative visited by FBI for downloading CP. They scanned his machines and left. Turned out there was no password on his router. A lot of people don't put passwords on their routers. A lot of people don't know that that's a thing that you can do. So yeah, we're going to just get to one or two more. Thank you so much. Question: defendants are supposed to be innocent until proven guilty, but as we see, we already have strong opinions on guilt for Josh and Brian. Do you think social media hinders their fair trial? I think it makes jury selection more difficult, but even with the Elizabeth Holmes trial, even with, I mean, a celebrity much larger than both of these cases, you still saw jurors coming in saying, I've never heard of this case. Jurors from Silicon Valley saying that they had never heard of Theranos, never heard of this Elizabeth Holmes, who was on the cover of magazines and in documentaries and all of it. So you can absolutely find people who are like, I don't do the social media. I don't like the Twitters or the Facegrams. I don't do the social media. So I think it makes jury selection a little more precise, but I also don't think it hinders their fair trial because that's up to their jury. So, and that's also where change of venue can come in. If something is really big in a small community, you can change the trial out of that community because everyone's heard of it. So, arguing the facts. If you can't argue the facts, argue the law. If you can't argue the law, pound the desk. Yeah, and object. It is a definite source of wisdom, and thank you, Felix, for that. Question: if Omi could prove that he ran everything through his lawyer, would he have a decent case? No, it's probably not going to shield him from criminal liability, but depending on the facts, he may have a malpractice case. But I don't. It's like I consulted my lawyer is not going to shield him from criminal liability in everything that's alleged, because there's a lot that's alleged there. That's not just how they did it. Like there's a lot that's alleged there. It'll be interesting. I mean, I'm sure we'll see motions to dismiss and we'll see other stuff coming. So we'll see. We'll see. Can you review the McDonald divorce case on one of your Friday Night Live? I know nothing about it. We don't do a ton of divorce cases on the channel, but I will take a look. We definitely have a lot of stuff. Question: Emily, have you heard the reporting that Tom Girardi told a reporter that he thought Erica knew what was going on? Dora, I saw the clip of the video. I didn't like that it was taken. I think it was kind of predatory of Page 6, but what are you going to do? I also didn't get the sense that Tom understood the question that was necessarily being asked. And in my opinion, it seemed that the question was so vague that it didn't really hint on, did Erica know what? Did Erica know about the legal? Did Erica know he was at the home? It didn't hold any like zingers for me. It just kind of made me sad. I'm like, it just kind of made me sad. So that's where I was. I saw it on social. So that was about it. Y'all, it has been 2.5 hours. Thank you for being Lawnards. Thank you so much for being here. I appreciate you. Next week is a little bit different because I will be traveling to speak at Bid Summit. I feel like a fancy YouTuber. And then there's some top secret stuff happening in LA too, and I'm very excited. It's going to be very, very interesting. So next week, there will not be a Coffee and Cursey Words on Tuesday. There will be a new podcast episode Wednesday. There will not be a Friday Night Live on Friday. There will be a ride at some point. I'm going to have to talk to the mods. There will be absolutely a stream at some point to talk about the Britney hearing from the 29th. It just depends on how the reporting comes out and how much information we get, whether that's on Wednesday or Thursday. It also depends on my schedule with being at Vid Summit. So yes, next week will be a lighter week. So if you do not follow me on social media, now is the time if you want to keep up with what I'm doing next week. At the Emily D. Baker on Twitter and on Instagram. If you want to join the Patreon, that's where the members only podcast lives, lawnerdsunite.com. If you like the merchy things, lawnerdshop.com will get you there. Thank you all for a great stream. Huge love to the mods. I'm glad you guys enjoyed the new emoji today, and we will see you soon. don't forget to listen to the podcast. Oh, and I did a unboxing of the new phone in a minute. A very far cry from my first YouTube video that ever got like more than 10,000 views, which was an iPhone 6S unboxing that is still up way deep in the archives of my channel, which did start with my love for tech. So thanks for being a law nerd. Thanks for hanging with me. Cheers. It was a busy night, but I will see y'all soon. Take care. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.